Good morning and welcome to the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Daly? Here. Senator Ellison? Present. Senator Flores? Senator Lang? Senator Rogish? Here. Senator Scheibel? Here. Senator Steinbeck? Here. Chair Pazina?
Present, and please mark Senators Flores and Lang present when they arrive. It looks like we do have a quorum, and we welcome our members of the audience here in Carson City, as well as those that are in Las Vegas and those joining us online. Before we begin, just a few housekeeping announcements. First, I'd like to remind everyone to please silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which have been listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of testifying. And if you do wish to testify in person, please sign in at the table by the door and provide Madison, our wonderful committee secretary, with your business card. When testifying in person, please turn the microphones on to speak and off to listen, as we have those that are also listening in Las Vegas as well as online. Please also state and spell your name for the record. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Committee members will be using their laptops to view handouts and other exhibits. Please do not view this as a sign of disrespect or inattention. And with that, just as a heads up to everyone today, we will be taking the bills out of order today, though we are starting at the top with Assembly Bill 112. After that, we'll move to Assembly Bill 434, Assembly Bill 121, and then close out with Assembly Bill 223. So with that, we're going to open up our first item on the agenda, which is a hearing on Assembly Bill 112, which removes an exemption from provisions providing certain employees with the right to use sick leave to assist family members. And we will welcome Assembly Member Wynn and his co-presenters.
Good morning, Chair Pazina, Vice Chair Daly, and members of the Senate Commerce and Labor Committee. For the record, my name is Yui Nguyen. I have the honor to represent Assembly District 8 in Southwest Las Vegas. I just want to first starting out by acknowledge my deeper appreciation for the chair for your accommodation to let me go first. I know that we have a busy morning playing musical chair with my committee, so thanks so much for your flexibility. It is my pleasure to present Assembly Bill 112, which would remove an exemption from provisions providing certain employees with the right to use sick leave to assist family members. Some background on this. One thing has become increasingly clear over the years is that no one should have to make the impossible choice between earning a paycheck and caring for their health or the health of a loved one. The evidence supporting this is overwhelming. Providing paid sick leave isn't only a win for working family, but it's also a smart move for businesses. As Nevada continue grow and attract new businesses and investors, we must recognize the foundational role our workforce plays in sustaining that momentum. When employees are forced to work while managing serious responsibilities at home, like taking a sick child to the doctor or helping a parent recover from surgery, it leads to burnout, low morale, and ultimately reduced productivity. But that's not just a labor issue, it's an economic one. Back in 2021, the legislature took a significant step by passing AB 190. AB 190 is required private employers offering sick leave to permit its use when an employee needed to care for an immediate family member. It made clear that the same standards applied to employees' sick leave would also apply in these family care situations, and that collective bargaining agreements, or CBA, would not be disrupted by this policy. However, we since learned that the access to family sick leave still varies dramatically. Depends on the worker's industry, job type, union status, and other circumstances. Employees covered by CBAs remain exempt from these protections, creating an uneven playing field. To add more to that story, I am joined by Maria Teresa Hank, a Southwest Airlines flight attendant and shop steward from Transport Workers Union, Local 556. And I would ask her to present her story.
Aloha, mabuhay. Good morning, Chair Pazina and members of the committee. For the record, my name is Maria Teresa Hank, and I'm a proud member of the Transport Workers Union Local 556. I'm here today to strongly urge the committee to support Assembly Bill 112, the KinCare Bill. As a constituent of Senator Rogich's and a single mother of two, I have dedicated 35 years of my career as a flight attendant. There are approximately 120 local unions in Nevada, and 118 of those unions, including our members, do not have the ability to call in sick to care for an immediate family member for short-term incidences such as illness, injury, or medical appointments. Instead, we are forced to call in sick for ourselves, an action that can lead to serious repercussions, including termination. I personally have 2 sons who live at home, but I'm also responsible for the care of my elderly 87-year-old mother who has dementia. If one of them needs medical care, or my mother is having a bad day and is confused due to her dementia, I have to make a choice of calling in sick and potentially losing my job, because we are currently exempt from using the current kin care law here in Nevada. AB 112 would address this critical issue for those of us who lack protection in our collective bargaining agreements. The mental and emotional toll it takes to be unable to care for a loved one in times of need is a harsh reality for many workers. No one in Nevada should have to choose between their job security and their family's well-being. I'd like to thank Assemblymember Nguyen for sponsoring this bill and President of CWA Mark Ellis for his hard work on this bill, and all the unions and community members who came together to bring this bill to you today. I respectfully ask you to pass this bill and get it workshopped this week so no working family member has to worry about losing their job to care for a sick family member. Thank you for your time and consideration.
Yui Wing, for the record, Madam Chair, if I may, if I'm going to go over quickly to the bill. Under current law, private employers that offer sick leave are required to allow employees to use their accrued leave, not only for their own health needs, but also to care for an immediate family members due to illness, injury, and medical appointments. So, just to repeat, this law is already in place. We're basically removing the last remaining exemption. This requirement does not apply to employees who are covered under a valid CBA. So that is what's currently at stake right now. Section 1 of AB 112 removes that exemption. This change means that employers would be required to extend the same family sick leave rights to all eligible employees, regardless if they are covered under a valid CBA or not. And Chair, just want to go over the amendment that I submitted to the committees. Is that there was a bit of a drafting error for some reason. The reprint amendment added the word paid time off benefit. AB 1112 does not address paid time off benefits. We are only looking at making sure that sick leave is the standard for every employer, regardless if they are under a CBA or not. Section 2 of the bill includes a transitional provision. The mandatory provision of Section 1 do not apply during the current term of any CBA enter or before October 1st, 2025. However, they will apply to any extension, renewals, or new agreements signed on or after that day. So I said this in the Assembly Commerce and Labor hearing when we introduced this in the other house. This just established a floor. It's very important that I say that. It does not limit or interfere with any additional benefits, rights, or remedies that may already be available to employees, either through their employer, a CBA, or state and federal law. With that, Madam Chair and committee member, we are ready for your question.
Thank you so much, Assembly Member and Ms. Hank, for being here today. And thank you for bringing everyone's attention to the amendment as well. I know there was some question when it came out of the Assembly and that you wanted to get it, the amendment into us before the hearing, which we appreciate, which again does take off paid time off. Do we have any questions from the committee? We'll start with Senator Steinbeck.
Thank you, Madam Chair, and thank you for the bill today. I appreciate the presentation. I have a couple of questions, if the chair will allow. First one is under Section 2, where it says an employer may limit the amount of sick leave that an employee may use to the amount that the employee accrues during a 6-month period. I was just wondering, what it says to the amount that they accrue during a 6-month period, but how long are they able to utilize that? Is that per year or is that per 6 months?
Yui Wing, for the record, thank you, Senator, for the question. That's actually already existing law. We're not changing any of that. But do you just want clarification on what that means?
Yes.
Okay, so this is just simply saying that the I think may need to call phone a friend on this one, Madam Chair. You waiting for the record. I think I may need legal to help me on this.
Thank you so much. Mr. Coulomé?
Thanks, Chair. Jeff Coulomé from the Legal Division for the record. So the reference in subsection 2 about the 6 month is taken sick leave pursuant to subsection 1. Subsection 1 doesn't seem to prescribe an explicit length of time. I mean, I think a common sense idea might be that it's within a single year, but I would need to look into that a little more specifically.
Okay. Yeah, I just wasn't there, so I wasn't clear at all, so I appreciate that. My other question is, the employer still allowed to ask for any verifications?
You're waiting for the record. I think that would be up to them in terms of their policy and the employees manual of that particular company. So they would be able to determine that internally. We do not stipulate that.
Okay. Thank you. And Madam Chair, last for the record, I am in support of obviously letting employees take care of their families and not having to make those choices. I appreciate it.
Thank you so much. I had a clarifying question, and this is just for my understanding. So if the collective bargaining agreement were to allow 5 days of sick time, and let's say the company allows 3 days of sick time, then would that be 8 days total? And this is just clarification for me because I didn't understand if this were to pass.
You waiting for the record, Madam Chair. We're not. This bill doesn't address the amount of sick time. This is just simply saying that you can use the sick time to care for a family member. So whether you awarded 3 days or you awarded 5 days for sick time, you can use that sick time, for yourself or for a family member.
Thank you so much. And I think I was just trying to understand, would it be the amount of sick time already stipulated within the collective bargaining agreement, and then adding to that the additional sick time that's also, and it's just my clarification so I understand, that's all.
You waiting for the record. I just want to phone a friend on this one because I'm not familiar with that. So you want to answer that, or Mr. Ellis?
Mark Ellis, Communication Workers America, Local 9413 for the record. It's the greater. It is not combined. So if you get 5 in your contract or 3 by state law, it would be the 5.
Thank you so much. And like I said, it was just clarification for my understanding, and I really appreciate it, and we really appreciate the presentation here today. I believe Vice Chair Daley has a question.
Thank you, Madam Chair. Also, just a clarifying question, and I did look up AB 190 from 2021. And I don't have a problem removing the restriction for people like your co-presenter there. But what it does say is, in the old bill, it says if an employer provides paid or unpaid sick leave for the use of his or her employees. So in most of the construction trades, you can get all the sick leave you want. You just call in and take time off because it's unpaid. So that's not going to require anyone to give sick leave under this change. So if the collective bargaining agreement is silent, the status quo remains, whether there's an exemption for a collective bargaining agreement or not in that circumstance. Is that the way you understand it as well?
For the record, Maria Teresa Hank, yes, it does. It does not create, it creates a floor. So whatever is the greater of the two is the one that they would use. It's not going to take any benefits away from people that already have that in their collective bargaining agreement. We're not asking for anything new. We're just asking to be included. Thank you.
Understood, and that's the way I was reading it, just asking the question.
All right. I believe that Senator Scheibel may have a question.
Thank you, Chair. And this may be more of a question for legal as well. I'm just trying to confirm where it says really in Section 1, subsection 1, if an employer provides paid or unpaid sick leave, that would apply to both employers who voluntarily provide paid and unpaid sick leave, as well as employers who are required by law to provide that leave, right?
Jeff Cooley from the Legal Division. Sorry, Senator, could you repeat the question?
Of course. So I understand that this bill applies to any employer who provides sick leave. My question is, does it apply equally to employers who are required to provide sick leave and those who elect to provide sick leave, even though they're not required to by law?
Jeff Cooley from the Legal Division. Off the top of my head, I can't think of a reason why it wouldn't. And I will also follow up on that and see if I can think of anything.
Thank you.
All right. Do we have any further questions from the committee? I'm not seeing any. So thank you both so much, and we'll have you take a step back, and we will welcome those who'd like to testify in support of Assembly Bill 112. We'll start in our physical locations, then move to the phones.
Madam Chair and members of the committee, for the record, my name is Annette Magnus, and I'm here today representing my client, Moms Rising Together. Moms Rising Together is a network of families here in Nevada and across the United States who are united by the goal of building a more family-friendly America. We are here today in support of AB 112 and thank the sponsor and all of the groups involved with this important bill for including us in the discussion. We believe that all workers in Nevada should have the right to use their sick time to care for themselves and their loved ones, and that no one should be disciplined for using their time to care for a child or family member who is in need. We urge your support of this legislation that will improve the lives of families across our state. Thank you.
For the record, my name is Mark Ellis, Communication Workers of America, Local 9413. We strongly support the bill. We should be able to take care of our family as well as ourselves. And to answer Skip Daly's question, when we were forming this, we made sure we didn't hurt our brothers and sisters in labor. This doesn't give anything extra. All it does is allow us to use sick time for our family members as well as for ourselves. Thank you.
Ross Kinson for the record. I'm the president of the Northern Nevada Central Labor Council and with Teamsters Local 533, and I ditto what my brother Mark Ellis just said. Thank you.
Good morning, Senators. For the record, my name is Susie Martinez. I'm Executive Secretary Treasurer of the Nevada State AFL-CIO, and I am also in full support of the bill. Thank you.
Good morning, Senators. Brian Orozco, B-R-Y-N-O-R-O-Z-C-O, and I'm in full support of AB 112.
Thank you so much. I don't see anyone in Las Vegas, so we are going to move to the phones broadcast. Do we have anyone who'd like to testify on the phone lines in support of Assembly Bill 112?
If you would like to testify in support of Assembly Bill 112, please press star 9 now to take your place in the queue.
Hi, my name is, good afternoon, and members, Chair and members of the committee. For the record, my name is Elizabeth Blewett, B as in boy, L-E-W-I-T-T, and I am a union member of TWU Local 577. I strongly urge the committee to support Assembly Bill 112. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Krista Gifford, and I am President and union member of TWU Local 577. I strongly urge the committee to support Assembly Bill 112. Thank you.
Good morning, Madam Chair and members of the committee. For the record, my name is Liz Sorensen. That's L-I-Z-S-O-R-E-N-S-O-N. I'm the president of Nevada State AFL-CIO, and I am in strong support of AB 112, and I urge this committee to do the same. Thank you.
Good morning, Chair and members of the committee. For the record, my name is Clarissa Principe, K-L-A-R-I-S-S-A,
PRINCIPE, and I'm a union member of Transport Workers Union, Local 577. As a worker, I've had many experiences over the years, but there's one particular that will forever live in my mind. There was a time when my mother was diagnosed with stage 4 uterine cancer and my father was deployed overseas serving our country. My mother was in pain and needed to go to the emergency room. I tried to get my shift covered and called my job ahead of time. They told me that I still needed to come in, and I told them I wouldn't be able to. Upon returning to work for my next shift, I was called into the office by my boss and was asked why I didn't just drop my mom off at the emergency room and come in to work my shift and pick her up after I was done. I had to tell my boss that that's something I would never do, and that my parents raised me, and if they needed me, I was going to be there for them. This is something employees should not have to deal with. I'd like to note that from experience, I realized FMLA has strict timelines and emergency rooms do not fill out FMLA paperwork. Getting an appointment with a doctor last minute to get FMLA for certain issues is nearly impossible to get within FMLA timeframes and results in a FMLA rejection. So at this time, I would like to strongly urge the committee to support AB 112. Thank you.
Good morning, Madam Chair, members of the committee. My name is Renee, R-E-N-E-E, Ruiz, R-U-I-Z. I'm with National Nurses United, National Nurses Organizing Committee of Nevada, and represent the interest of 3,000 plus RNs across the state of Nevada, and we are in full support of AB 112. Thank you.
Caller with the last 3 digits of 591, please press *6 to unmute yourself. Thank you. Please continue.
Hi, this is Addie Crisp Johnson. I'm a member of TWU Local 556, and I'm calling you guys to strongly encourage you to support AB 112 as a parent of small children or middle school children and of a 100% disabled veteran, a daughter of a 100% disabled veteran. There's been things that have come up last minute, and this would have been really helpful. Thankfully, I have a lot of family, so I haven't had the problems other people have had in my workplace, but I strongly encourage you guys to support this.
Yes, good morning. Jason Vargas for the record, JASONVARGAS, TWU Local 502, represent American Airlines underneath the wing here in Las Vegas, and I strongly urge the bill AB 112. Thank you.
Caller with the last 3 digits of 357, we can see you are unmuted. Is it possible you're muted on your end?
Hi, can you hear me?
Yes, we can.
Okay, thank you. Good morning. For the record, my name is Valerie Shaw, VALERIE, I am a TWU Local 556 member, and I am in support of AB 112. Earlier this year, the reason this is important to me, my mother was diagnosed with a heart condition that required immediate open heart surgery. And although I was very lucky that I had friends that were able to work my shifts for me, she has required a lot of follow-up appointments, a lot of doctor's appointments and therapy that she's not able to drive to. And I do have family members that can help me, but every now and then I do have to take her to those appointments. And under my company's current policy, I am not able to call in sick to take my mother to those appointments without abusing the sick leave policy, which can result in discipline, including and up to termination. My story is just one of many stories, and this is why I'm in support of AB 112, and I urge all of you to support it as well. Thank you.
Good morning, Madam Chair and members of the committee. For the record, my name is Gabe Christensen, CHRIS Tenson. I'm the state legislative director for Smart TD. I represent the switchmen, conductors, and brakemen for the railroad in Nevada. We strongly urge you to support AB 1112. We shouldn't have to make a choice when it comes to taking care of our family. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Thomas Bird, Thomas, last name Bird, capital BIRD. I'm a union member out of local IBEW 1245, and I strongly urge the committee to support Assembly Bill 1112. Thank you.
Caller with the last three digits of 653, please press *6 to unmute.
Good morning, Madam Chair and members of the committee. I'm a member of the Nevada Disability Pre-Action Coalition, and as people with disability and we do work, we wholeheartedly support this bill, and we thank the sponsor for bringing this bill forward, and happy Cinco de Mayo for those who celebrate. Thank you.
Good afternoon, Chair and members of the committee. For the record, my name is Clarence McCarthy, CLARENCE, MCCARTHY. I'm a member of National Association of Letter Carriers, Branch 709 in Northern Nevada, and I strongly urge the committee to support Assembly Bill 112. Thank you.
Good morning, Chair and members of the committee. My name is Russ James, for the record, with the Nevada AFL-CIO, RUSSJAMES. I am in strong support of AB 112, and I urge the committee to support it as well. Thank you.
Hi, my name is Keon Johnson, and I'm a member of TWU Local 556, and I strongly urge you to support the AB 112. Thank you.
If you recently just joined us, we are currently in support of AB 112. If you would like to testify in support, please press *9 now.
Good morning, Chair and members of the committee. My name is Sue Bird, SUEBIRD. I am in full support of this bill. As a senior in Nevada and my children, adults, I never know when I may have to depend on them. And having family crisis, you want to make sure that your children are protected too. As the parent, you don't try to call on your children unless you really have to. And when you have to, it's very important. And to think that they may lose their jobs to help a parent is unthinkable. Please support Bill 1112. Thank you.
Good morning, Chair and members of the committee. For the record, my name is Paul Peterman, PAULPETERMAN, and I'm a union member of the National Association of Letter Carriers, Branch 2502, Las Vegas, Nevada. I urge the committee to support Assembly Bill 112. Sick leave dependent care is important protection for members who have to take care of their children or their parents. Thank you.
Chair, you have no more callers in support at this time.
Thank you so much. With that, we will open up testimony in opposition of Assembly Bill 112. We'll start in our physical locations and move to the phones. And not seeing anyone approaching the tables in our physical locations, broadcast, long time no talk. We're back to you. Anyone on the phone lines who'd like to testify in opposition of AB 112?
If you would like to testify in opposition of AB 112, please press star 9 now. Chair, you have no callers in opposition at this time.
Thank you so much, and that will bring us to neutral. Do we have anyone in our physical locations who'd like to testify in neutral? We will welcome you, and then we'll go back to the phone lines.
Good morning, Madam Chair, members of the committee. Paul Moratkin with the Vegas Chamber. The Chamber is in neutral in AB 112. We appreciate the work that's been done by the bill sponsor and the community on this issue. We are supportive of the amendment that has been submitted to Nellis to clarify this pertains to sick leave only. As the committee members know, there is a differentiation in law between sick leave and paid time off, and so we appreciate that, and we look forward to this bill's passage with the amended form. Thank you so much.
Thank you, Chair Pazina, committee members, Misty Grimmer, GRIMMER, representing the Nevada Resort Association. I do believe we are in neutral on the bill for the similar reasons to what Mr. Moradkin stated. There has been some confusion in the conversations about the sick, because there was another bill on the Assembly side that didn't cross over that also created some confusion about which set of statutes apply to sick leave and which sets of statutes apply to the PTO benefit. As was referenced earlier, PTO is a mandatory benefit. Sick leave is a optional benefit for employers to provide. I don't know if the chair would indulge us if maybe legal could just clarify that AB 112 only applies to sick leave and not to the PTO benefit. I don't know, and like I said, I would appreciate your indulgence if it was possible for legal to clarify that.
Thank you for your testimony, Ms. Grimmer. And Mr. Coulomé, you've been very popular this morning.
So it seems. Thank you, Chair. Jeff Coulomé from the Legal Division. To your question, the conceptual amendment that was uploaded onto Nellis does explicitly propose to remove the reference to the paid time off benefit language in paragraph E, and I believe the Assembly member stated that also on the record that was not his intent that be included, and that was some kind of a drafting mistake that phrase was included. So it's my understanding at this time that the proposed amendment would strike that paid time off benefit language, and to your point, then it would be out of there, and the plain language would be clear that the sick leave benefit is the only benefit being referred to in the section.
Thank you very much for your indulgence, Madam Chair.
Thank you, Chair and committee members. Joe Hill, Policy Analyst for the Retail Association of Nevada. We would like to echo the comments made by the resorts in the Chamber and would like to thank Assembly Member Nguyen and stakeholders for their work on this bill. Thank you.
Thank you so much. And with that, we are going to move to the phone lines. Broadcast, do we have anyone on the phone lines who'd like to testify in neutral on AB 112?
If you would like to testify neutral on AB 112, please press star 9 now. Chair, you have no callers neutral at this time.
All right. If you'd like to make any closing statements for us.
Thank you so much, Madam Chair and Committee. Yui Wing for the record. Again, we just want to thank you for all your time this morning to listen to this presentation. And, this is just another step towards fairness, towards supporting our families, and towards reinforcing our shared values of health, dignity, and economic resilience. I look forward to talk to all the senators, of course, offline if you have any more remaining questions, but we look for your support to this bill.
Good morning, Madam Chair. Maria Teresa Hank for the record. I do want to just reiterate that this will create a floor and not a ceiling for union members that already have language in their CBAs. And I also want to make sure that you understand fully that we are not touching PTO or paid time off. And I did want to thank one extra person. Her name is Annette Magnus from Moms Rising for all of her hard work in bringing together all of the stakeholders. She did an amazing job. And thank each of you for indulging me, whether it's in the hallways or actual meetings. Thank you for your time.
Thank you both so much. And with that, we thank you for the presentation, and we will close the hearing on Assembly Bill 112, and we will open the hearing on Assembly Bill 434, which prohibits certain employment practices, and we will welcome Assembly Member Anderson.
Good morning. Good morning, Chair Vazina, Vice Chair Daly, and members of the Commerce and Labor Committee. My name is Natha Anderson. It is my honor to represent Assembly District 30. I'm joined today by Ross Kinson of Teamster Local 533 to present AB 43, legislation which is similar to laws adopted in 8 other states. I can give you those states if you really need it. But before doing so, thank you, Chair, for giving us this opportunity to present this. I know you've got a very busy schedule, so we've tried our best to keep it a little bit shorter when it comes to the presentation. Mr. Kinson, if you'd like to kind of start us off with the Chair's permission, if I may.
Thank you, and for the record, again, my name is Ross Kinson. So ultimately, this Assembly Bill 434, we've called it the Worker Freedom from Employer Intimidation Act, and it's rooted in a basic, deeply American value, which is freedom of thought and belief. It is a simple question: should anyone in Nevada be forced to choose between keeping their job and staying true to their conscience? And today, the answer is unfortunately yes. In many workplaces across our state and across the country, employees are required often, without warning, to attend meetings or receive communications that focus on their employer's political or religious views. These meetings are sometimes called captive audience meetings. They are not about job performance or safety or business updates. They're about influencing belief, about political campaigns, union drives, or even religious affiliation. These meetings are typically mandatory. Employees cannot opt out, and that's something that we need to make very clear. They cannot opt out. If they do, they risk discipline, loss of shifts, demotion, or even being fired. So that's what we're trying to solve, right? We've heard from workers in Nevada that have sat silently in these meetings. They're heart pounding, knowing that they disagree, but fearing what would happen if they said a word or walked out. And ultimately, that's not freedom, that's coercion. So AB 434 changes that. It says if your employer wants to talk about politics or religion, they can, but you as the employee do not have to listen, and they cannot punish you if you choose to leave that meeting. So the bill simply restores, in my mind, balance. It recognizes that workers are not just employees, but they're people of their own values, their own beliefs, their own political agency, and they should be able to show up, do their jobs, and go home without being forced to absorb messaging that has nothing to do with their work.
So again, Nathan Anderson for the record. Thank you, Mr. Kinson, for kind of explaining where exactly the bill came from. I can walk you through it pretty quickly, and I will do so, bless you, by the way, twice. But before doing so, I also want to make sure this is clear. This is not a conversation between an employer and employee. In the perfect work world, that's what you want. You want to be able to trust and respect management and the worker enough to be able to just have those sort of conversations that allow for people to both disagree, but also the grace to agree. It's when their mandatory meetings take place where people feel that they have to be present, that they have to listen to something that they are very much against. I think that this is one of those times when somebody will stand up and say, you need to vote for this person. You need to join a union no matter what. You need to drop a union no matter what. That's where the problems are occurring. This is a person's belief system. This is what we're trying to allow for a job not to be tied to a job performance, a job continuation, not to be tied to automatically being told that you must agree no matter what with management. This is allowing somebody to be respected for their own beliefs. So with the chair's permission, I'd like to walk through the bill and very quickly. Under this legislation, employers are prohibited from disciplining, retaliating against, or firing workers who decline to attend a meeting or participate in communication where their primary purpose is to share the employer's political or religious views. This includes efforts to persuade employees to vote a certain way, address unionization, or adopt specific religious beliefs. After conversations with other members of the labor community, Section 1.3 was added in to strengthen the enforcement by allowing workers who experience retaliation to seek damages, lost wages, and attorney's fees. We also clarified that this applies to both state and local government employers, because public employees, of which I'm a member, deserve the same protection. We respect existing exemptions for religious institutions, keeping in line with Nevada law and the First Amendment. I think the larger thing as well is the belief that if someone's job is at stake, they must automatically agree. That is not what we're trying to do. That is what this law is actually trying to fix. We should be able to disagree with each other. Mr. Kinson will go into why exactly it's being brought up at this time.
Again, Ross Kinson for the record. So ultimately, the need for this legislation is growing. Across the country, we're seeing an increase in employer use of captive audience meetings, particularly in anti-union campaigns and political mobilization efforts. These meetings are often framed as informational. However, if we're being honest, when your boss tells you that you need to be somewhere and that it's not a request and that they need to talk to you about something that's political in nature, that's not neutral ever in nature. And so other states, as Assemblymember Anderson has talked about, have put this in place. Connecticut, Oregon, and Minnesota have passed similar laws. California, a similar bill has gained traction, and courts have upheld these laws multiple times. Most importantly, workers in those states now have the freedom to walk away from coercion. So it's time, as far as we're concerned, for Nevada to join them.
Assemblymember Anderson for the record. This bill is about dignity, it is about respect, and it is about being able to trust each other. And a bit before the Assembly hearing, there were some that came to me and said, well, wait, how is this infringing on First Amendment rights? It brought up concerns about restricting employer speech. Employers can still say what they like. This is not, though, telling somebody they must attend this meeting no matter what. During the Assembly hearing, one of the members also brought up that at one point she was told, well, you must attend this mandatory prayer meeting. Now, this was not in our state. This was in a different state many years ago, but that is reality in many areas. Employers are free to express their views. They are free to say this voluntary prayer meeting will be taking place. That is voluntary. But saying that you must attend is a problem. Employees don't have to participate in this expression and should not be punished for making a choice by those who hold the position of power. I guess what I'm trying to say is we need to respect each other. And we need to respect the ability of people to disagree and do so with grace and dignity. The Worker Freedom from Employment Intimidation Act is a step towards restoring the power and autonomy that every Nevada deserves at work. There were further concerns brought up about, let's say, a barista wearing a button that was supporting a person. That uniform is still under the employment or under the management of the employer. That's not saying you can do that. But it is saying I do not have to attend a speech telling me that I must support this specific candidate. That's what this is about. It also is not saying, hey, we've got to do a training about how to address people in a better way, in a proper fashion. That training is directly related to the job. What is not related is telling somebody that their views are wrong. I just ask for your support so we can clearly show Nevada believes in the rights of the workers and the freedom to speak or not speak without fear. And at this time, we're happy to answer any questions to the best of our ability. Thank you, Chair.
Thank you. Do we have any questions from the committee? I'll ask a quick question. I noticed the exclusion for religious organizations, and I was curious too about political organizations like the RNC or the DNC. Was there ever a thought in regards to an exclusion there?
Assemblymember Anderson, for the record. Yeah, I feel like those sort of things, that's almost part of it. Did not think about putting that into the language itself. More than happy to do so. But let's say that also you were employed as a lobbyist. That's something that you must do. That's part of your job. But if you are instead, and I'm just going to use a county as the example, let's say that you're working for the county recorder. You attending a meeting, and you're a filing clerk. You attending a meeting about politics would not make sense. You are assigned though, or you're hired as a lobbyist, it would make sense. And so those sort of items are very specific to the job. But I do appreciate that clarification, and if we need to, we can definitely easily do so.
Thank you so much. It just occurred to me when you were speaking about supporting a specific candidate, since the parties can be so fractured right now from maybe moderate to more, be it left or right-leaning candidates. So at any rate, any other questions from the committee? Okay, Senator Steinbeck.
Thank you. I just wanted to kind of talk a little bit about the burden of proof as far as, what makes it a rise to this level. And just, some examples, like if an employer was to have a meeting and just start to talk about different policies or some proposed legislation that was going to make changes in their industry, I could see how that could be viewed as, supporting a candidate or not supporting a candidate, but may not be the intention, and then I could see that being a gray area here.
Through the chair to Senator Steinbeck.
You can go direct, and thank you.
Thank you. Assemblymember Anderson, for the record, thank you for bringing that up. So let's say that you're in an industry that has to do with, let's say, construction. Prime example. Great example, as a matter of fact. And there might be some legislation that has to do with safety of the workers, right? Which I believe there is currently. I can't remember exactly which number it is. That awareness of it, I think mentioning it is one thing, but telling the employees you must write a letter, you must contact your person, that's a problem. Telling somebody about AB 123, which is, by the way, not the bill, so that does not need to be now referred to, or let's make up a different number, AB Z144, that's not saying you must write the letter. But if you just mention it, that should be okay. That is not part of the burden of proof. If, however, you say you need to turn in that letter that you have sent in to your legislator, showing that you have supported it, that's a problem. Because that's then infringing on somebody's freedom of speech and somebody's decision whether or not to agree or disagree with that legislation. That then is saying, you must show me that you've done what I've asked you to do. Mentioning it is one thing. Showing somebody that they've done something is something else entirely. And again, mentioning it in passing is one small thing. Spending an hour and a half on something is much larger. And that's where I envision that. Mr. Kinson, if you want to add in.
Yeah, Roskins, for the record, I completely agree with the assembly members' comments. This is for if you're requiring your members to sit down and have a meeting that, again, has to do with whether it be religion, politics, anything like that, where you're forcing, if it's a training or anything like that, I mean, this is something we've had a lot of conversations around, that wouldn't be part of this. But if it's that you should support this candidate or you should support these political ideas, or there's like a call to action associated with that, then that's where we see that this bill would then have legs.
I could see it, I mean, even going past training, right, that maybe an employer would say, hey, if this particular bill passes, I'm going to end up having to lay off half of the staff, right, or a quarter of staff, or whatever that may be. And I could see that being an endorsement or non-endorsement.
Assemblymember Anderson, for the record, that concern was brought up. I've asked for some clarification language from the individuals who have brought it up to me, and I don't believe that they have offered any to be able to bring up those clarification things. I do understand that where that idea is coming from. It is, however, the bashing of it, the continual bringing up of things. I could bring up some things happening federally that just, it becomes then the only thing you hear as opposed to somebody's personal beliefs being attacked. Thank you.
Last one, ma'am. Thank you. And then, so also, if an employer wanted to talk about the effects that unionization would occur, would that also fall into this?
Roskins, for the record, yes. So again, employers are allowed to talk about these things. It's just that they cannot require their employees to sit down and sit in a meeting and listen to it. If those employees say, listen, this isn't something that I'd like to sit down and listen to, I'd like to get up and leave, they would then have the right to do that. That's what this language talks about. And yes, unionization would be included in that.
Thank you for the questions and answers. Thank you.
Do we have any, Vice Chair, did you have a question? Okay.
Hey, thank you, Madam Chair. Just a comment based on the last little part of that. So obviously I've been around and heard of many captive meetings regarding unionization. You can tell when you're in one. I think the questions that my colleague was asking in those regards, I've never heard of anyone going to one. Never heard of anyone where we've had a person go in and record what was being said, where the employer didn't commit an unfair labor practice in that meeting. There are certain things you can say, and there are many things you cannot, whether or not they got prosecuted under that. So I think this, we just had Star Wars Day, so I would tell the employees that, we're going to get up and walk out. Your Jedi mind tricks are not going to work on me.
And we all hope the 4th was with you yesterday, Vice Chair. Do we have any other questions from the committee? Okay. Not seeing any further questions, we thank you both so much for the presentation, and we'll have you take a step back so that we can take testimony in support of AB 434. I would remind everyone that we do have 2 other bill hearings after this today, so try to keep your comments to 2 minutes, and we thank you all so much.
If you are comfortable with this, are you okay if I leave to go back to my committee?
Understand completely.
Greatly.
We've all been there. Please head on back.
I thank everybody for the time. Always happy to talk.
And we thank you for being here today. And we will welcome those who are testifying in support of AB 434.
Good morning once again, Senators. For the record, my name is Susie Martinez, and I am the Executive Secretary Treasurer of the Nevada State AFL-CIO, and I'm going to make it short, sweet, and simple. We are in full support of the bill. Thank you very much.
Mark Ellis, President, Communication Workers of America, Local 9413. Like Susie said, ditto.
Maria Teresa Hank, Transport Workers Union Local 556, ditto.
Brian Orozco, BRYAN, OROZCO, TWU 556. I'm in support of this legislation.
Kent Irvin, KENT, ERVIN, Nevada Faculty Alliance, in support of AB 434. The question was brought up of political organizations, and we had that question on the other side too, but there was language added in Section 1, subsection 2B, that talks about bona fide job performance. So if you're hired to knock on doors and deliver a message, I think a briefing of your script certainly would be within a job performance. That's different than being told personally to believe in whatever you're saying in the script or taking action on that. So we're in support of the bill.
Thank you so much. And not seeing anyone else in our physical locations, we are going to move to the phone lines. Broadcast. Do we have anyone on the phones who'd like to testify in support of Assembly Bill 434?
If you would like to testify in support of Assembly Bill 434, please press star 9 now to take your place in the queue.
Walt Peterman, National Association of Letter Carriers, Branch 2502, Las Vegas, Nevada. Chair and members of the committee, I strongly urge the committee to support Assembly Bill 434.
Good afternoon, members of the committee. My name is Tom Bird. I'm president of a senior organization here in Nevada called the Alliance for Retired Americans. I strongly urge the committee to support Assembly Bill 434. Thank you all.
Good morning, Chair and members of the committee. For the record, my name is Gabe Christensen, Christenson, State Legislative Director for Smart TD. We ask you to support AB 434.
Good morning, Madam Chair, members of the committee. For the record, my name is Liz Sorensen. I'm with the Nevada State AFL-CIO, and I am in strong support of AB 434. I urge this committee to do the same. Thank you.
Good morning. For the record, my name is Joseph Graham, JOSEPH, GRAHAM. I'm the Chief Steward for Communication Workers of America, 9413. I strongly urge the committee to support this bill. Thank you.
Good morning, Madam Chair, members of the committee. My name is Renee Ruiz, RENEE-RUIZ. I'm with National Nurses United, National Nurses Organizing Committee, and we strongly support this piece of legislation. Thank you.
Good morning, Chair and members of the committee. For the record, my name is Clarence McCarthy, CLARENCE MCCARTHY. I'm a union member of National Association of Letter Carriers, Branch 709 in Northern Nevada, and I strongly urge the committee to support Assembly Bill 434. Thank you for your time.
Good morning, Chair, members of the committee. My name is Russ James, RUSSJAMES with the Nevada AFL-CIO. We are in full support of the bill. Thank you.
We are currently in support of Assembly Bill 434. If you would like to testify in support, please press star 9 now. Chair, you have no more callers in support at this time.
Thank you so much. With that, we will close out testimony in support and move to testimony in opposition of Assembly Bill 434. We'll start in our physical locations and then move to the phones.
Good morning, Madam Chair, members of the committee. Good to see each and every one of you. For the record, Trey Abney, TRAYABNEY, here representing the hardworking job creators of NFIB, National Federation of Independent Businesses, Nevada. We strongly oppose AB 434, and we believe this is a vast government overreach. The nebulous terms here could make almost any opinion or pronouncement by an employer a violation. On the first day you were here in this building in this session, each of you swore to protect and defend the Constitution of the United States. Well, business owners have First Amendment rights, and we believe that the provisions of this bill violate that. Any business owner should be able to, on their own property, explain to anyone they want to about how certain issues or bills or ballot initiatives or candidates may positively or negatively affect their ability to do business and keep their employees, employed. If an employer holds a regularly scheduled, all hands on deck staff meeting, and somewhere in that agenda she or he decides to pontificate on the importance of registering to vote and participating in the political process, and those staff members are required to attend that staff meeting, that employer would now be guilty of violating the law. If an employer wanted to invite Senator Cortez Masto to address their employees or explain to them how awful tariffs would be for their business and their livelihood of their employees, they would now be guilty of violating the law. To Senator Steinbeck's point, this bill says nothing about calls to action or forcing you to sign anything. It says matters related to. And now their employees can sue them for holding a meeting. Madam Chair, if this bill prohibited employers from forcing employees to sign the dotted line to become a Republican or a Christian or whatever, you wouldn't have to put up with my face again here in front of you today. But this bill is an unconstitutional overreach that we could never support. and we urge you to oppose it as well. Thank you for indulgence and your time.
Mr. Abney, I'm going to have you sit tight. I believe the Vice Chair has a question for you.
Just a quick question and some of your testimony there in opposition about people being in violation of the law. I believe they would only be violation of the law if the employee left the meeting and the employer retaliated. Isn't that really what the words say? If the employee left and the employer retaliated under the circumstances that you described, they don't have to stay. They can go back to their regular job, do their work. That's the only time this would kick in. Is that incorrect? It's what I read the words.
For the record, Trey Abney, NFIB, thank you, Mr. Vice Chair. Political matters means matters relating to. So if they want to, if the employer says, we're going to have an all hands on deck meeting, all staff on deck, and we're going to talk about the importance of registering to vote, this would violate that. And so if you
Only if the employee left and the employer retaliated.
For the record.
Just read the words.
For the
That's what I'm
record,
telling you.
For the record, Trey Abney with NFIB, if you start allowing your employees to decide each and every time what they think is icky or what they think is political, it certainly doesn't provide for an opportunity for a cohesive and responsible workplace. Thank you, Madam Chair.
Mr. Coulombe, can you confirm on Assembly Bill 434 whether this becomes unlawful once retaliation is taken? And thank you so much.
Thank you, Chair Jeff Coulombe from the Legal Division. So in subsection 1 of section 1 of the bill, the plain language refers to an employer in the state to discharge, discipline, discriminate, retaliate, or take any other adverse employment action against, or threaten to take any such action against an employee because the employee declines to attend a meeting sponsored by the employer or declines to participate in, receive, or listen to any communication by the employer or an agent or representative thereof. So by the plain words there, I think the way I read it is consistent with the Vice Chair's description. It's about retaliation if the employee declines to attend or participate in the meeting, and then if the employer takes adverse employment action against or threatens to take adverse action against.
Thank you so much, Mr. Coulombe, and thank you so much, Mr. Abney. And we will go to Ms. Grimmer.
Thank you, Chair Pizzina and committee members. Misty Grimmer, representing the Nevada Resort Association. The concerns that we have with the bill are similar to Mr. Abney, that there isn't enough clarity in the bill as far as what would be the definition of a religious or a political matter. And some of the required meetings that our employees are required to attend, such as ethics training or harassment training, some people could easily perceive that as something that's political if they don't agree that whatever you're saying is an ethic or unethical. And so we do have concerns with that. We did oppose the bill on the Assembly side and worked with the Assemblywoman to agree to let it move over here to the Senate and keep working with her on some potential amendments to make sure that it doesn't interfere with the regular employee meetings that we're required to have people attend. We are also concerned about the magnitude of the penalties in the bill. We do already have statutes that deal with unlawful employment practices, and the penalties that are currently in this bill go beyond what the other ones in the statute are. But we'll keep working with the Assemblywoman and see if there is a resolution to be found. But currently, we're in opposition. Thank you.
Good morning, Madam Chair, members of the committee. For the record, Paul Moratkin with the Vegas Chamber. The Chamber has also opposed AB 434. We have met with the bill sponsor. Appreciate her time, of course, in those dialogues. We do have some additional concerns with the bill. We do have, of course, as the committee members know, the Chamber has a long-standing position about objection to language that includes private right of action and legal courses against an employer, which is found in Section 1 of the bill. We also have concerns, as Ms. Grimmer mentioned from the Resort Association, regarding what could be defined as a political activity. As many of you know, there are many trainings that we have to conduct on policy matters. If an employee in the current environment we live in decides to object to attending that meeting because they don't agree with the policy, because it's a state or federal regulation they may not agree with because of the administration, that could put the chamber or its members in jeopardy of that in compliance with those training regulations. So there's a concern with that. And also in conversation with the bill sponsor, we just want to clarify from the chamber's knowledge, when there's a staff meeting on the private employer side, you are compensated to attend those meetings. Just as a general situation, when you're attending a staff meeting, there was some clarification about if employees are paid or not to go to trainings, the staff meetings. From our perspective, they are. That may be different in the public sector, so I just want to clarify that. And then finally, we are concerned about the call to action comments that were made. An employer has a responsibility to let employees know if there's a particular piece of legislation that may negatively impact the industry and may put people out of work and so forth. They do have a responsibility to let them know that legislation is occurring. So we just want to clarify that, and we'll follow up with the bill sponsor about call to actions and email communications and so forth as well. So thank you for your time today, Madam Chair and committee members.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. The city is in opposition to Senate Bill 434, and specifically the expansive definition of political matters that is in Section 1, subsection 5A, and we would be happy to continue to work with the sponsor to maybe tighten that definition up a little bit. Thank you.
Good morning, Madam Chair and members of the committee. For the record, Miranda Hoover with 3C House, representing the National Electrical Contractors Association, Northern Nevada Division. We share the same sentiments as other comments made before us and are seeking additional clarity on this bill, and we look forward to continuing to work with the sponsor and other stakeholders. Thank you.
Thank you so much. And with that, we are going to move to the phone lines. Broadcast, do we have anyone on the phones who'd like to testify in opposition of Assembly Bill 434?
If you would like to testify in opposition of AB 434, please press star 9 now.
Thank you, Madam Chair and members of the committee. My name is Emily Osterberg, and I'm calling in representing the Henderson Chamber of Commerce and our over 2,000 members. We are also in opposition of this bill, AB 434, for the reasons previously mentioned. We appreciate working with the Assemblywoman and just continue to look forward to more conversations. But for the reasons previously mentioned, we are also in opposition. Thank you.
Chair, you have no more callers in opposition at this time.
Thank you so much. Broadcast, we're going to stay with you for a moment. Do we have anyone who's in neutral on Assembly Bill 434?
If you would like to testify neutral on Assembly Bill 434, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. We will go to our physical locations. Is there anyone who'd like to testify in neutral on Assembly Bill 434? Not seeing anyone coming forward. Mr. Kinson, would you like to make some closing comments?
Thank you. Again, Ross Kinson for the record. So I just want to address a couple of things that were brought up. First and foremost, are we limiting employer free speech rights with this bill? Not at all. Ultimately, employers can still express their opinions on political and religious matters. This bill does not prohibit that speech. It simply protects employees from being forced to participate. I know that seems obvious, and we've continued to say that throughout the hearing, but I feel like I need to repeat it again. This is, it protects the employees from being forced to participate in speech under threat of job-related consequences. It's not restricting employer speech. It's protecting the freedom of belief. It's protecting the freedom of association. And ultimately, both of those are guaranteed under the First Amendment, and that includes the right not to listen, especially in the workplace where power dynamics are very unequal and will continue to be unequal. So that's why this bill is necessary. That's why this bill is important. We hear what the folks who spoke in opposition are saying. We appreciate the conversations that we've had with them, and we'll continue to have those conversations. However, the core and the heart of this bill is that right there. So thank you for your time. Really appreciate
I
it.
did have one more question before you step back. I was curious. The assembly member had mentioned maybe 8 other states that were doing this, and I was curious, I guess, one, if there'd been any legal challenges, and 2, if private right of action was included in those states. And if you don't know right now, that's no problem at all. I'd just be curious.
Ross Kinson for the record. So as far as private right of action, I will get back to you on that. However, in the first hearing, that was something that was brought up. And so one of the things that we had looked into was, in those other states, was there a flood of lawsuits or anything like that? The response to that is no. In speaking with our with the Teamsters up at the IBT level and having them do some research for me, there are no frivolous lawsuits. There's not a flood of litigation. Ultimately, what we've seen is a culture shift, and there has been less and less cases of bad actors having those captive audience meetings. So this is language that works. This is language that has been tried and tested in other states, and we haven't seen what the folks who are speaking in opposition are saying in those other states.
Well, thank you so much for your time, and I will be curious to hear how further stakeholder discussions progress.
Thank you.
And on that note, we are going to close the hearing on Assembly Bill 434, and we are going to open the hearing on Assembly Bill 121. And we welcome Assemblymember Considine, and thank you for coming down from Government Affairs to join us. Assembly Bill 121 revises provisions governing landlords and tenants, and we are ready when you are.
Thank you, Chair. Venetia Considine for the record. I don't know if this is possible, but I brought a couple of examples that I got to pull together today, and I don't know if they're copyright issues, so I just brought copies. I didn't know if these could be handed out to the committee members.
Yes, if you'd like to share those with our committee secretary, we'd be happy to take a peek, and thank you. Thank you so much. Also, I'll remind the committee there is a conceptual amendment to Assembly Bill 121 that's available in Nellis. And with that, we will take a peek at these, and please begin when you're ready.
Thank you. Thank you, Chair Pizzina and members of the Senate Committee on Commerce and Labor. I am Venetia Considine, and I have the honor of representing Assembly District 18. And thank you for the opportunity to present Assembly Bill 121. AB 121 brings transparency and certainty to families seeking to rent a place to live by requiring that the rent amount advertised is the actual amount tenants will pay. This is not a new issue. I was here 2 years ago presenting AB 218. That bill passed the Assembly and the Senate, but unfortunately did not become law due to the governor's decision to veto the bill. Since then, 2 national entities who have thousands of units in Nevada have been sued by the FTC for practices that this bill tries to end. One is Invitation Homes. Invitation Homes reached a $48 million settlement with the FTC last year for deceptive trade practices against renters, including hidden and junk fees. Consumers found out about the price of the rent, that it would be higher than advertised only when they sat down to sign their lease or when they paid their first month of rent. This settlement requires Invitation Homes to advertise true rental prices. The second is Greystar Apartments, which is the biggest multifamily rental property manager in the United States. They were also sued by the FTC. The FTC complains that Greystar consistently omits various mandatory fees from the advertised price of available units, and under the guise of cheaper rents, they can attract more prospective tenants. The FTC suit alleges that Greystar has collected more than $100 million in fees from just tenants in Colorado, California, Nevada, and Utah. It's $100 million in 4 states. This is money that Nevadans could have spent on groceries, childcare, goods, services, or saved to buy their own home. Rent is the highest bill that tenants have to pay, and it is deceptive advertising to list rent that is lower than what tenants are being charged. Tenants trying to find an affordable place to live based on their budget deserve to know what they have to pay up front. And this is what AB 121 tackles. I'd like to start with the bill, but also start with Section 5, subsection 6, because this is the heart of the bill, and this is on page 5 in the blue. This section says that where any rental cost is listed, the amount must include all non-optional fees. Many landlords are charging separate fees, and these are some of the fees that they charge separately: for trash, sewer, entertainment packages, a technology fee, a maintenance fee, luxury fees, concierge service fees, internet, air conditioning filters, air conditioning maintenance, community fees, pest control fees, building fees, the landlord's rental insurance, the landlord's property taxes, water 1, water 2, water 3, a porter fee, a utility management fee, a trash consulting fee, and then service fees for those fees. One example, I just want to highlight, I got this last night. There's an 82-year-old woman living in an apartment in Las Vegas. I don't know if you can see this, but she is paying $30 a month for her Cox Internet. She's been living at the same apartment for a very, very long time. She's gotten a mandatory notice for all residents in that apartment that they have gotten a deal from Cox. Everyone in every apartment will now have to pay $65 for their internet. It's mandatory. She doesn't have a choice. She's going from having a $30 bill that she pays on her own to $65 more in her rent. Not part of the rent total, but on top of the rent, and it's a mandatory fee. So this I just got this weekend as an example. And again, they are claiming that these additional fees are not rent, they're separate fees. But this resort-style fee pricing is detrimental to a person trying to plan their monthly budget when they're seeking a place to live. This change will provide transparency and certainty for someone living to paycheck, which is a very large segment of our Nevada population. And it provides relief and consequences to corporations and landlords who do not provide the actual amount of the rent with all mandatory fees as the cost for the periodic rent. And this is what Section 6 covers. To be clear, the fees required to be included in the rent under AB 121 do not include truly optional fees, like if you have a pet or you want to pay for a garage. These only include things that you're required to pay every month that were not included in the listed price of the rent. This is one number, one price, so the tenant knows what they're paying every month. It also provides fairness and competition because some entities are showing the full amount of the rent, but someone up the street is not. And the tenant will only find out when they sign the lease or they get their first bill on their app. Then they'll find out that they might have chosen the apartment complex with the lower rent advertised, but now they're paying $100, $200 or more every month. And this is after they've made their non-refundable deposits and signed the lease for the rent, for the apartment. Now, opposing stakeholders argue that it's not possible to figure out the actual amount of the rent because there are variable costs, so they should be allowed to have additional fees for anything that could be variable. As I mentioned when I listed some of the variable costs that I've seen and tenants have told me, it appears that almost anything can be variable. Even when the fixed cost for 12 months for an item is known, for example, sewer or trash, you know what that item is for a full year. But just about all of these costs were included in the periodic rent until about a dozen, and all of those costs that I mentioned were included in periodic rent until about a dozen years ago, or right around the end of the Great Recession. And by far, most leases are for 1 year. They are not decades-long leases where it's impossible to figure out the math and determine the cost responsibly. What I am seeing is that many landlords and property managers are outsourcing the responsibility to determine the rent to companies like RealPage or Conservice or utility tech stack fintech companies with proprietary software. And many Nevadan tenants are receiving their monthly statements from entities like Conservice. And those are sort of the couple of the statements that I showed you. And it looks more like a CPA ledger. These are difficult for Nevadans to decipher. And a statement provided by me shows that unit charges for water are not even based on how much of the water is actually used in the unit, but it's divided by the square footage of the apartment. It also shows that the rate determination for these charges can go out to 7 digits beyond the decimal point. And of course, there are fees for all of that as well. So I believe that the math can be done, and you could have a one price, one for one rent. Another issue after speaking with many stakeholders that keeps bubbling up was utility water. So in the conceptual amendment, I have, after speaking with them, the amendment you should have, allows multifamily and apartments where individual units are master metered. And if you're unfamiliar what master metering is, it's that there's one meter for the entire apartment building or the complex. There are not individual units for each apartment. So in specific cases where they are master metered, I have put into the conceptual amendment that cost, that 1 unit water use cost, can be separated out from the rent as long as it is noticed wherever the amount of periodic rent is listed. And for the property managers and landlords who have argued against the bill because individual home rentals, they claiming where it's not possible to have tenants contract directly with utilities, I've also included an amendment to deal with that. And now that amendment is where it is not possible for the utility to directly contract with the tenants for water, gas, or electric, that the amendment requires such notice as they would notice with the rent. I hope that all makes sense. So, okay, so that's kind of the whole concept around Section 6. Now, going back to the beginning parts of the bill, these are much shorter. Section 2, this simply requires a free way to pay your rent, because right now there's a fee to pay your rent in many cases. This would allow payments for rent to be paid by money order or cashier's check or a check without having to use a portal to make those payments. Some people don't have bank accounts, they're underbanked, or they just don't want to share their personal banking information that could later be sold, scraped, or stolen. This does not prohibit a tenant from choosing to pay rent through the portal with the fees associated. They could pay it however they want to pay it, but it gives them a right to pay it without having to pay a fee. But the bill does require that if there are portal fees for bank charges, credit card charges, or for the operator of the website portal just to pay your rent, that those fees must be identified and written into the rental agreement. Now, the Apartment Association was worried about the language in Section 2(1)B, which says provide information concerning a bank account for those things that people shouldn't have to do. Their interpretation of that means that they are not allowed to accept a check. So the amendment tries to make very clear that that section does not preclude any landlord from accepting a check. Section 4 requires that only upon request, a landlord or agent of a landlord can provide a copy of a written rental agreement that the tenant would be subject to. This is a boilerplate lease, so they know what the lease requires and allows them to review all the lease provisions and addendums before making a decision to put down a non-refundable fee or a couple of non-refundable fees. I've seen leases that are 30 pages. I've seen leases that are 40 pages. I've seen leases that are 50 pages. This lease is 52 pages long. Every one of these little red are tabs. Every one of these is a separate addendum to the lease. And this lease is a boilerplate lease from the National Apartment Association. It's on legal size paper. This, again, has 19 addendums. It's over 50 pages long. Many of these addendums are about additional fees, maintenance shifting agreements, things that say you agree to change out your air filters, you agree to do the maintenance that would be required for the landlord to do, but now you are agreeing to do it and paying for it in issues like batteries and air filters. And interestingly enough, on this one, if I may read from this for a second, because this one I hadn't seen before, towards the back there is, and this is, I think, this would be addendum number 17, is a photo and video release addendum that states that any likeness of you or any minor occupants residing in the unit or the apartment complex can be used in photos, electronic or digital media can be used in any publication that the video or photos belong to the landlord or the company, and that you agreed to irrevocably authorize them to alter the photos or the videos, copy, exhibit, publish without any limitations, et cetera, et cetera. And that's in this lease. And often the tenant is signing the lease on their phones because the lease is being sent to them. It's sort of tap, tap, tap to sign here, sign here, sign here. Rarely are they doing it with a person. And to my knowledge, none of these have been negotiable. On Section 4.5, this requires that in cases where a credit application fee was paid but the credit activity was not completed, that the fee is returned. It also prohibits collecting an application fee or credit application fee for a minor who is a member of the household of the prospective tenant. So this just stops what I think is a bad practice. And then Section 3 is a penalty section for deceptively listing the rental amount that is not the true amount of periodic rent. Now, I mentioned earlier that the bill 2 years ago was vetoed by our governor. The governor's veto message included 2 reasons for vetoing the bill. One reason stated for vetoing the bill was that it would be, quote, it would be impossible for a landlord to comply with this bill without amending the original lease. Just want to make clear, this bill never stated, and AB 21 still does not intend or state that existing leases between landlords and tenants would have to be revoked or revised. To be clear, this bill does not break existing contracted leases, and that was never the intent of the bill. The bill is for leases entered into during the effective date of the new law. The second reason that the governor stated for vetoing the bill was that if a landlord was found by a court to have violated the deceptive trade practice law in the bill, a court would have to order the statutorily required treble damages. And again, this goes back to Section 3. To resolve that concern, we have removed the deceptive trade practice piece from the bill and lowered the damages to just $250. If not for those 2 issues, these practices could have been stopped 2 years ago. I've worked to ensure that this bill protects tenants, removes the governor's issues, and resolves the issues brought to me by stakeholders. I know it's a lot, but thank you for giving me the time and the opportunity to present AB 121, and I am happy to answer any questions.
All right. Thank you so much, committee. Do we have any questions? Senator Ellison.
And good morning. I know never to rent an apartment from anybody. We have rentals. We got, most of them are straight fees by the city in City of Elko or whatever. So what you do is when you go into to take each individual rental, you have to pay like $110 a month, plus you have to pay the garbage, whatever. And that's included in the rent. And after looking at these rent prices, I'm really choking myself to death. We add that into our apartment, or our not apartments, but rentals. And at that point in time, it's a set fee. So when they pay the rent, it's $650 or whatever it is a month, that's included. So actually, if you figure the difference, because the city won't let the renters pay the utility bills. It's up to the landlord. So you got to add that in. So by the time they get done, they're paying $500 a month rent. So when I look at these, I've never seen anybody change batteries or whatever. We do all the maintenance, 100%. So I was kind of shocked to see some of the stuff that's in here. But these are large apartment complexes, is that correct?
Thank you for the question, Senator Ellison, Venetia Constein, for the record. So these are large apartment complexes. These are individual property management. I've seen them across the board, but this is something that I think has only come up in the say like the past 12 or 15 years. So to your point, it has been in the past that you could figure, as a landlord or a big corporation business, you could figure out all of those costs and put them into the rent. I don't know why they started pulling them out of the rent while still raising the rent and having them separate. And you're a fine example of someone who could do all of that together and have one price, one thing for rent. But it is the apartment complexes are easier to show because they all have boilerplate leases, but this is also going on in individual units and individual properties. Thank you.
And what about increases, like say the city or the county or whatever raises the rates, ad valorem taxes or whatever? Usually you try to pass that on to the renter, but that's usually like once or twice, once every 2 or 3 years. So that doesn't create a problem with this bill, is that correct?
Thank you for the question, Venetia Constein, for the record. So by far, the majority of leases in the state are 12 months long. So you have to sign a new lease at the end of any lease term. So anytime any price goes up, once a year, once every 2 years, once every 3 years, the landlord just fixes that or incorporates that in the new amount of the rent in the next lease. Does that answer your question?
Yeah, we didn't even do that. Okay, thank you.
Okay, do we have any other questions from the committee? Okay, Senator Rogish.
Thank you, Chair. After the 12-month lease is up, and if the tenant goes by month, is there an increase also because they haven't signed on for another 12 months?
Thank you for the question, Senator Rogic. Venetia Considine. For the record, if they're on a new month-to-month lease, the landlord does have to give notice 60 days in advance for any raises of the rent. So they would be able to do that. Yes, they can raise the rent, and if it's on a month-to-month lease and the term of the lease is at the end, there is always that ability to add in additional costs. I might have the timeline a little bit wrong with the notice that they have to give, but I do know there are folks down south who are helping with the next bill that will be able to answer that very quickly. Thank you.
Okay. Thank you so much. Not seeing any further questions from the committee, we thank you for the presentation, and we will have you take a step back from the table so that we can welcome testimony in support of Assembly Bill 121. We'll start in our physical locations and then move to the phones. I would remind everyone who's testifying today to please keep it to 2 minutes because we have another bill yet to go today, and we want to make sure we have time to hear it. So thank you so much. And with that, you may begin here in Carson City when you're ready, and then we'll move to Las Vegas.
Bija Oamwa, na Calboon Menania, na Agaida. Good morning, my name is Cal Boone, Calboone, and I'm a citizen of the Walk River Paiute Tribe. My apartment, Tanglewood Village here in Carson, utilizes the Loft Living online portal for payments, formerly called Active Building. I'm thankful that I have another option to make payments for my rent and water, but not everyone does. My water bill ranges around $90 to $100, and to pay online, I would have to pay an additional fee of $52.36, known as the convenience fee. Whether I am paying my rent for the month, which is over $1,700, or a bill under $100, the convenience fee is still the same to process an online payment. The pass-through rate for Loft Living payment processing typically falls around 2.75% per credit card transaction. The convenience fee makes sense for rent, but not for small bills like water. I fully support this bill because not everyone has access to pay through a money order or other means. Additionally, I think Section 2, subsection 2B, which reads, the amount of any fee charged to the tenant by the landlord or his or her agent for the use of the internet website or online portal must be separately identified in any written rental agreement. This would make a profound stride towards transparency of hidden or unexpected fees. So with this, I would hope that all fees that may be charged to a tenant should be separately identified on the rental agreement for awareness and preparedness. Thank you.
Good morning, committee. My name is Emmy Miranda, Emymiranda. I am in support of AB 121. I personally did go through this in last year in December when I had my first apartment, and I was told it was $1,800, and then when I signed the lease, my first rent was up to $2,100, and the stress that put me as a full-time student and working at a part-time restaurant was extremely hard. And I had a dog at the time, so I did have a pet fee. I had those cleared when I first signed my lease. However, then I had more and more fees that were being added on, and I wasn't aware of these, nor was I told. And I struggled to have food. I had to decide whether me or my dog would eat, and I would eat at my restaurant where it would be free. It would be a soup. And it was days of crying and trying to see if I would make it to the next rent. So I think that this bill, making it transparent for tenants to know what they're going to be paying for, is important. So if we can avoid issues like this in the future for others, I think that would be amazing. So please support AB 121. Thank you for your time.
Good morning, Chair Pazina, members of the committee. My name is Ben Innes, that is Beniness. I'm the coalition manager for the Nevada Housing Justice Alliance. We're a statewide coalition of grassroots organizers, community advocates, who work with tenants throughout the state to establish long-term and meaningful tenant protections to push back against our state's housing crisis. We're here in support today, addressing or acknowledging with our high cost of living and historically high rents. As the UNLV's Lead Center reported last year, 60% of Nevada renters are cost burdened, which is the, I think, second highest rate in the country next to California, which means each and every month they're paying over a third of their rent in that precarious position of balancing high rents, essential food, medication, clothing, transit, etc., and trying to stay stably housed and not become displaced. Hidden or surprise fees make it difficult for tenants to accurately budget and afford rent. This severely impacts all tenants, including low-income renters, seniors, students, or households on a fixed income. Undisclosed fees, prevent tenants from accurately comparing rental prices, making informed choices about their housing, and creating accurate and manageable household budgets, all leading to increased chances of housing instability, which again is the core thing that we are trying to prevent. AB 121 is an important tool for maintaining transparency and accountability for tenants while giving them a stronger sense of security as they budget each month. Thank you for hearing the bill, and thank you, Assemblymember Considine, for her work. Thanks.
Good morning, Chair Pazina and members of the committee. For the record, my name is Tara Webster, Tarawebster. I'm the policy manager with the Progressive Leadership Alliance of Nevada, here in support of AB 121. Tenants in Nevada have struggled to keep up with unchecked rent increases, uninhabitable living conditions, and predatory fee practices, and mandatory payment portal fees, as you've heard. Renters are also being forced to choose between paying their rent or buying essentials like food and medicine. We're here simply to say that tenants need a break. We urge your support. Thank you.
Thank you, Chair Pazina, members of the committee. My name is Ashley Kennedy, spelled Kennedy, representing Clark County today. I am here in support. As many of you probably know, Clark County has various social service programs where we help tenants, our constituents, your constituents, navigate finding affordable housing. In that, our continuum of care in that housing space, we are constantly working with tenants to find places that they can afford. And so for this transparency, as we're working with clients to ensure that they know what they're going to be paying, and that we are helping them find places that they can afford, and they don't end back up in a place that they're coming back to Clark County for rental assistance because they were in a place they couldn't afford. So we believe in transparency, and that this helps tenants navigate the system. Thank you.
Thank you so much, and we are going to move to Las Vegas. Please begin when you're ready, and thank you.
Good morning, Chair and members of the committee. My name is Ariana McConnell, ArianaMcConnell. I'm a third-year student at the William S. Boyd School of Law and a student attorney with the Tenants' Rights Legal Residency that's in partnership with the Legal Aid Center of Southern Nevada. All of Nevada, but especially Las Vegas, is in dire need of reform to expand the need of affordable housing, deterring bad faith corporate landlords, and improving the summary eviction process. It's no secret that corporate landlords have permeated our rental market, and it's prompted negative publicity and federal investigations into their deceptive trade practices. AB 121 presents a well-rounded and measured approach to tackling payments, fines, fees, and advertising. It should be signed into law to benefit the whole of Nevada's rental market. The bill changes nothing for many good faith landlords who are already fairly representing the total amount of rent due each month. In fact, the market pressures would reward these landlords as non-compliant properties unearth all of their hidden fees to play by 121's rules. Some of the largest private rental companies have been sued by the FTC, and in my short time reviewing residential ledgers, I've seen my clients facing recurring fixed monthly charges for the active rent reporting, cable TV, computer access, valet trash, in addition to regular trash, vague service fees, common area maintenance, common area electric, residential benefit packages, and more. But AB 121 reinforces a system of sustainable renting. It creates better matched landlord-tenant relationships because tenants are going to be informed of their total expected monthly payments before signing the lease agreement, and it's making it more likely to have them make satisfactory rent payments. So tenants living in these rentals that are advertised within their means are a win-win for everyone, and I strongly urge you to start with passing AB 121. Thank you.
Good morning, Chair, members of the committee. My name is Casey Atherton, for the record. I'm also a third-year law student at the UNLV a William S. Boyd School of Law, and an advanced clinic student in the tenants' rights legal residency. I'm here today in support of AB 121. AB 121 is about fairness and transparency in the landlord-tenant relationship. It addresses everyday issues that tenants struggle with, like unexpected fees, unclear rental terms, and barriers to payment that put already vulnerable renters at great risk. This bill ensures tenants know exactly what they owe by requiring landlords to list rent as a single total amount, including any fixed mandatory fees. No more surprise charges tacked on after the fact. It also protects tenants from being forced to use payment methods that require a bank account or come with hidden fees. Many tenants must pay rent through online portals that charge service fees high enough to affect whether they can afford to live until their next paycheck. And some landlords misuse these systems, blocking access to payment portals to push out those who they consider to be undesirable tenants via summary eviction for non-payment of rent. Rent should be payable without added costs and barriers. This bill is about setting clear rules and holding landlords accountable to them. It doesn't punish good actors. It just makes the process more transparent and accountable for everyone. I urge the committee to support AB 121. Thank you.
Thank you all so much, and thank you for being here today. Just a reminder, we're going to keep it to 2 minutes per person, and if you want to say ditto, that's okay too. And again, we thank you all for being here.
Good morning, Chair and Committee. My name is Alice Sandberg, ALICESAMBERG. I'm also a third-year law student at the William S. Boyd School of Law and an advanced clinic student in the law school's tenants' rights legal residency. I'm testifying in support of AB 121. This bill is a substantial step forward in supporting Nevada's tenants. It will protect them from being unjustly overcharged or falling victim to deceptive pricing structures. It will increase transparency, accessibility, affordability, and fairness in the housing market. One of the most important additions is the requirement that all rental agreements clearly state the amount of rent as one figure, including any fixed mandatory fees. This is critical because too often tenants are lured in by low advertised costs only to find surprise fees added later on. This reform ensures that tenants know exactly what they will pay. It also ensures that tenants are not forced to use online systems to pay rent. In an era where digital payments are common, the addition of Section 2 is especially important because it guarantees that low-income or unbanked individuals are not penalized for lacking specific financial tools. AB 121 is a balanced reform that addresses long-standing tenant concerns without placing undue burdens on landlords. I urge the committee to adopt this bill. Thank you for the opportunity to speak.
Thank you so much, and it's great to see how bright our future is with our wonderful Boyd Law students here today. Beautiful job. Mr. Norman.
Chair, members of the committee, Jonathan Norman, NORMAN with the Nevada Coalition of Legal Service Providers. We ditto the comments and just would add, we see tenants every day coming to the self-help center who are 2 months into their lease, realizing all these hidden fees that are adding up and making the unit unsustainable. Fundamental to people being able to budget is knowing what they're budgeting for. And when you have leases, the Assembly Member Considine mentioned a 50-page lease, but we've seen leases over 60 pages, which I think the Invitation Homes lease was 62 pages with all the addendum. It makes it hard for people to even understand what they have to pay for. And also having a way to pay rent, not through a portal, senior law program, which is one of our members, just assists people over the age of 60. And it is very difficult if they have to navigate a portal online for many seniors. So I think that's really important to point out. It's one of their biggest foot traffic issues. And finally, NRS 118A.300 has the notice of rent. It is, Assemblymember Considine was correct, 60 days. It's less if the lease period is less than a month. It's only 30 days. Thank you so much.
All right, and welcome to our last speaker in Las Vegas.
Hi, yes, my name is Jaira Mendez, YAJAIRARIMENDES, and I'm a proud member of Make the Road Nevada. And I urge lawmakers to support AB 121 fully. It strengthens our tenants' protection to regulate landlords' handling of rent payments. It also protects us from junk fees, free fund security deposit, and provide easier tenant protections. As a 35-year-old with cancer, I have issues with my former landlord who was charging me for junk fees, especially if anything will break or replace, I had to pay out of pocket. I paid $1,500 extra on top of the security deposit, on top of the key fee, cleaning services, as well, also maintenance. And I had paid another $2,000 for the first month in security deposit, which I struggled paying the bills or paying rent. And due to my struggles with cancer, being a low-income person, I urge all to support AB 121. Thank you.
Thank you. We will take one more person in Las Vegas and then we're moving to the phone lines.
Good morning, Chair, members of the committee. My name is Tamara Favors. I'm reading for a community member, Jalen Neal. Good morning, Chair, members of the committee. My name is Jalen Neal. I'm a mother of 2 children who have been living in Las Vegas for 7 years. I'm asking you all to pass AB 121. I live in Assembly District 6 and I live in Senate District 6 and Assembly District 34. I've lived in many apartments in the current apartment that I've moved in and into after being willfully kicked out of my partner's home. I was able to roommate during that time, that process. I've had difficulties finding a new home for my family. During the search, I was looking for a new home. I saw many apartments with a list of fees that didn't count towards the rents. And even after my searches, I was able to find a new home. I was hoping to find a new home that was affordable, yet after living there for 2 months, I was getting various fees tacked onto my rent. My rent was first $1,400, and within the span of 2 months, it rose up to $1,600, and now it is $2,100. However, I was never made aware of these mysterious fees when it comes to paying my rents, a gate fee, a light fee, and etc. I'm a single parent, and my children solely rely on me. If I keep randomly getting fees tacked on, I'm worried about where me and my children will live. Thank you for hearing my story, and I urge you to pass AB 121 for families and people like me.
Thank you so much for being here today. And we are going to move to the phone lines where I believe we have a number of callers. That's our last one in Las Vegas for the time being and maybe on this bill. But we are going to move to the phone lines for AB 121. Do we have anyone in support?
Okay.
If you would like to testify in support of AB 121, please press star 9 now to take your place in the queue.
Good morning. Could you all hear me okay?
Yes, please continue.
Okay, thank you, Madam Chair. Good morning to you and Vice Chair and members of the committee. This is Dora Martinez with the Nevada Disability Peer Action Coalition. We wholeheartedly support this bill, and we hope that you do too for the average Nevadans. I heard a lot of tragic stories. One of our bus drivers who makes $17 an hour sign on to a lease and comes to find out on top of $1,300 a month, he has up to $600 extra that was not on the original lease. We also we love the idea that for website to pay rent, as you may all know, I'm blind, and some of the websites that some of these apartments are using, which I am in one now, is not accessible. We had to fight to get to do a money order or check because the website is not accessible to people who are blind. And I can only imagine it's probably not accessible to people who are American Sign Language because, ASL is different from English speaking folks. Thank you so much for your valuable time. Enjoy the weather. Take care.
Good morning, Madam Chair and members of the committee. My name is Renee Ruiz, Renee Ruiz, and I am testifying on this bill as a Las Vegan and a renter. When my husband and I decided to move back to Las Vegas, we were scrambling to find a rental home. Homes are extraordinarily hard to find for rent. And when we did, we were shocked by the length of the lease not in terms of days, but in terms of pages. I personally work on contracts, negotiate contracts, and, work on policy and practice for nursing as my profession, and I struggled to get through the contract. I was also disheartened to find that within the contract, my husband and I were responsible for additional maintenance fees as they came up. So in an older home, as maintenance fees happen, we would be responsible to pay a certain amount for each time we called the management company to have routine maintenance done on the home that we rent. In addition, there are rent what is $300 to $400 a month more monthly than we initially agreed to. And this is not acceptable. We do have the luxury that we are not a couple that lives paycheck to paycheck. And I can only imagine that this amount is life-changing and a struggle for every family out there that does not have the same luxuries that we have. And so I strongly urge the committee to support this bill. This is good for all of Nevada. Thank you.
Thank you so much. And everyone, just a reminder to keep it to 2 minutes. Otherwise, we won't be able to hear too many more callers, and we really want to. So thank you.
Hi, good morning, Chair, President, and committee members. My name is Brian Harris. I'd like to ditto all the comments that were stated before me. This is a good bill, and I urge you all to support it. Thank you.
Thank you, Mr. Harris, for showing us all how it's done. Next caller, please.
Hi, my name is Jenna Vella with Battleborn Progress. I just want to ditto the comments that were before me in support of AB 121 because renters in Nevada deserve clear, fair, and transparent housing practices. Thank you.
Caller with the last three digits of 153, please press *6 to unmute. Again, caller with the last three digits of 153, please press *6. Thank you. Please continue.
I'm so sorry. My name is Katrina Grigsby, Catrina, Grigsby, Grigsby. Nevada Homeless Alliance, we're in support of AB 121. I think it's really important for landlords to be transparent about all those other fees. We've seen situations where we were going to assist a client, we see one charge on the reservation sheet, we approve and get ready to pay, and then all these fees pop up. Often these are not configured into the client budget if they're working with an entity, and often some of the funding sources deem those costs unallowable as they are not included in the rent as they should be. So again, I urge you guys to support AB 121.
Hello, my name is Sarah, and I am with the Make the Road committee. Thank you so much for hearing me today. I just want to ditto everything. Also want to add that a lot, and I'm talking about 90% of everything, pardon me, that is befallen the other speakers is something that I have been struggling with in my time as a renter here in Las Vegas and in Nevada in whole. And I am very much, in favor of this bill being passed. So thank you so much for your time, and thank you for hearing us. It is a desperate situation since my rent went from $1,100 to $2,100 in the last 2 years. Thank you so much for your time. Have a good day.
Good morning, Chair Pazina and committee members. For the record, my name is Matilda Miller. That's Mathilda Miller, Government Relations Director, Native Voters Alliance Nevada. We're in strong support. Thank you.
Hello, can you hear me? I'm sorry.
Yes, please continue.
Good morning. My name is Rochelle Clark, ROCHELLE, Clark, CLARK. I'm here to talk about AB 1221. My rent now is 1045. My lease is up for renewal. They mentioned to me 1126, and now they're telling me that if I don't do it before July, it'll be 1265. So I'm in support of AB 121.
CYRUSHOJJATY. We'd like to thank the sponsor for this great bill. I'm not a fan of regulation always, but this is a really, sometimes regulation like this can actually help. I'm just frustrated how the base rent is $1,300 and then all the other costs come in and it goes to like $1,600, $1,700. So please pass this bill and fingers crossed that it doesn't get vetoed. Thank you.
Chair, you have no more callers at this time.
Thank you so much. With that, we will close testimony in support, unless those that are in Las Vegas would like to just give their name and say, I support. Without any other comments, I'd be happy to get it on the record that they support the bill. I'd also remind you, if you have comments to give, if you'd like to submit those to our committee secretary, we would love to accept those as well, and the information to do that is on the agenda. With that, we are going to move to testimony, not seeing anyone come forward, in opposition to Assembly Bill 121. We'll start with our physical locations, and then we will move to the phone lines.
Good morning, members of the committee. My name is Harrison Bohn, HARRISON BOHN. I'm on behalf of Nevada Multifamily Alliance and Ovation Development in opposition of AB 121. We want to acknowledge and thank the sponsor for the opportunity to meet with her numerous times this session on AB 121. We agree with the underlying policy goal and believe greater lease transparency can help renters understand their financial obligations. But we're here in opposition because the all-in number is insufficient to provide the true transparency in practice for renters and landlords. We believe a required explanation or addendum outlining each fee would help the marketplace function properly for a few reasons. First, renters need to know what they are getting with that all-in figure. This can include mandatory fees like additional amenities or services. This breakdown and explanation could help educate renters on what their lease actually includes without sacrificing transparency. Second, renters should be actually able to compare two different rental units in a search for a home. Not every unit or complex has the same amenities, and consumers should be able to quickly compare an addendum to find a unit and community that best fits their needs. Third, while we can provide our tenants a clear breakdown of their financial obligations in their lease, we want other members of the industry to be held to a similar standard. This industry is highly competitive, and encouraging full transparency across the industry will ensure there is a level playing field. An addendum would work like a receipt to detail all required charges, which is something universally accepted across different industries. When consumers have access to clear pricing information, they can make more informed choices. The all-in number alone does not provide enough clarity and could create confusion for the renter and create inequalities for the landlord. For these reasons, we oppose AB 121, but I will acknowledge that I feel like we're close, but we'll continue to work with the sponsor if the bill continues to evolve. Thank you.
Thank you so much. And not seeing anyone else in our physical locations, we are going to move to the phone lines. Broadcast, do we have anyone who'd like to testify in opposition of Assembly Bill 121?
If you would like to testify in opposition of AB 121, please press star 9 now. Again, if you would like to testify in opposition of AB 121, please press star 9 now. Chair, you have no callers in opposition at this time.
Okay, that will bring us to neutral on broadcast since we're already with you. Is there anyone on the phone lines who'd like to testify in neutral on Assembly Bill 121? And you can go ahead and come to the tables in our physical locations as well. And then when we're done with the phones, we'll head to you.
If you would like to testify neutral on AB 121, please press star 9 now. Chair, you have no callers neutral at this time.
Sounds good. We're going to go to you then, Miss Elliott.
Good morning, Chair Pazina and Vice Chair Daly and members of the Senate Commerce and Labor Committee. For the record, I'm Mindy Elliott with Flynn Judici Government Affairs, today representing Southern Nevada Regional Housing Authority and Nevada Rural Housing Authority. We want to thank Assemblymember Considine for working with us and several of the stakeholders on the amendment to Assembly Bill 121. As in the Assembly, we did have our concerns. We appreciate the collaborative approach in refining this bill and look forward to ongoing dialogue if necessary to ensure that tenant protections and operational feasibility remain balanced. We thank you for your time and consideration. It's nice to be neutral on this particular piece of legislation. Thank you.
Thank you so much. Not seeing anyone else in neutral, we are going to invite the stakeholder back to the table if you have any closing comments.
Venetia Constein for the record. I want to thank all of the committee members for looking at the documents, for asking questions, and for allowing me to present. And the only other thing that I do want to say is as to the opposition, I've tried very hard to find bridges for all of the opposition, but I don't believe that this is transparency, and adding another addendum to another of these red tabs is not, in my opinion, consumer protection friendly and provide transparency. And with that, I thank you for your time.
Thank you so
Madam
much.
Chair, can I ask a question, please?
Yes.
Okay, thank you. Just about the opposition. So, as I understand it, then, as far as the transparency, you would have the total amount that would be due listed clearly, but there'd be nothing preventing a breakout of that. Is that correct?
Thank you for the question, Senator Steinbeck, Venetia Constein for the record. If what they wanted to do was add like one list of everything that is included in the rent to this, that is absolutely fine. But what my understanding the opposition is they want to be able to attach an addendum of all of the fees that are not included in the rent. So that, again, it's not the number one rent. That is my understanding.
Oh, okay, that's what I want to clarify. So
Okay, thank you. I just didn't know if you had a follow-up, and I didn't want to cut you off. Okay, perfect. With that, we thank you so much, and we are going to close the hearing on Assembly Bill 121, and we are going to open the hearing on Assembly Bill 223, revising provisions relating to the habitability of rental property, and we will keep it to 15 minutes, and then remember 2 minutes each for those that would like to testify on all sides of the bill. And with that, we'll have you get started. Thank you.
Thank you very much, Chair Pazina, members of the committee. Again, I am Venetia Constein, and I represent Assembly District 18. Thank you for the opportunity to present Assembly Bill 223 to this committee. AB 223 proposes a number of necessary changes to habitability law, all of which will ensure safer and healthier housing for all Nevada residents. Constituents have contacted us with issues in their rental units: black mold, broken air conditioners in the peak of summer, water that doesn't run, unsafe electrical outlets, and more. Common sense and Nevada law tells us that no one should have to endure those living conditions while paying rent. Tenants facing habitability issues shouldn't face a lightning-fast summary eviction without the opportunity to have a decision on the habitability issue. No one wants an unwarranted eviction on their record, and especially it's difficult when they expect a habitable home and it turns into a nightmare. But our current law puts people in this exact untenable position. AB 223 allows tenants to be proactive in resolving unsafe living condition in 3 main ways. First, it eliminates arbitrary decisions in eviction cases by removing language that has allowed loopholes that don't actually require that unsafe conditions be fixed. Second, AB 223 allows tenants to pay reduced rent when a landlord fails to comply with habitability laws. And third, and most importantly, it empowers tenants to file their own verified complaint if they are forced to live in an uninhabitable condition without being taken to eviction court. In habitability cases today, the only way to get in front of a judge is at the request of a landlord. So this additional avenue will allow tenants to access our court systems for habitability issues without putting them in an eviction hearing simply for expecting a landlord to fix unsafe conditions. To walk us through the bill, I have two third-year law students in Las Vegas, Alice Sandberg and Casey Atherton, who are student attorneys in the Tenants' Rights Legal Residency Clinic at UNLV's Boyd School of Law. And they will introduce themselves, and they have short presentations, if they can, Chair. Thank you.
Chair, members of the committee, my name is Casey Atherton, Kaceeatherston for the record. Thank you to Assemblymember Considine for the opportunity to speak to you. Alice and I are third-year law students at the UNLV Boyd School of Law and advanced clinic students in the Tenants' Rights Legal Residency. Through that program, we've represented tenants in eviction cases as student attorneys. We've seen where Nevada's habitability laws break down for tenants and how easy the summary eviction process can be used against them, even when they're just trying to follow the law. One client's story shows just how Nevada's habitability laws fall short. We'll call her Jane. In the middle of the scorching Las Vegas summer, Jane's AC began leaking badly. The unit was tucked away, so she didn't notice until water soaked her carpets, damaged her furniture, and black mold began spreading across the walls. Even worse, mushrooms had sprouted from the floor. In Nevada's dry climate, this level of moisture should have raised immediate red flags. Jane reported this issue to her landlord, but nothing changed. Twice, unlicensed maintenance workers came by, but no repairs followed. Her AC kept leaking. To stop the mold from spreading, Jane shut off her AC entirely and endured the heat without relief. She eventually sent a formal letter to her landlord describing the mold and mushroom growth. It was ignored. After waiting the required 14 days, she withheld rent. The landlord responded by filing for eviction. The day before the hearing, someone showed up at Jane's apartment, not to fix the problem, but to hide it. They scraped up the mushrooms and spray painted over the mold. At the hearing, the landlord told the judge that everything had been fixed and demanded that Jane pay the withheld rent. Jane had brought photos and evidence, but the court issued a status check. Months passed, no further repairs were made. Jane still had no AC. Realizing the court considered her landlord's cover-up sufficient, Jane knew she had two choices. She could either pay rent for a still uninhabitable unit or be evicted. Tenants like Jane shouldn't have to move just to live in a safe condition. For families, that can mean uprooting children from school and facing unaffordable moving costs. AB 223 gives tenants a fair way to address unsafe living conditions before receiving an eviction notice and holds landlords accountable when they fail to act. NRS 118A was meant to protect these rights, but it isn't working the way it should. AB 223 fixes these issues and ensures the law works as intended. Now I'll turn things over to Alice, who will explain how the bill makes those improvements.
Good morning, Chair and Committee. This is Alice Sandberg for the record, ALICESAMBERG. We've submitted written testimony with a complete walkthrough of the bill, but in the interest of time for this hearing, I just want to focus on a few key improvements AB 223 makes. Each one was added in direct response to the problems we've seen play out in eviction court. The first issue under current law that should be highlighted is that tenants cannot seek relief from a habitability issue until their landlord files an eviction against them. In other words, a tenant must risk eviction and homelessness in order to get in front of a judge and to ask their landlord to remedy unlawful, uninhabitable conditions. This bill addresses this problem in Section 4 by creating a path for tenants to seek expedited relief without risking eviction in order to do so. The second issue under current law is that pro se tenants are often penalized for technical missteps despite meritorious claims. Specifically, most tenants we've encountered are unaware of the requirement to deposit their withheld rent into the court's escrow account. Because they fail to meet this requirement, it's common for an eviction court to preclude a tenant with a meritorious claim from asserting habitability as a defense in court. Instead, these tenants are evicted and the landlord is able to re-let the unit without addressing the habitability violations. AB 223 recognizes that current habitability law is especially unforgiving to tenants who, without legal training, face harsh consequences despite their best efforts. Specifically, Section 11 levels the playing field by letting tenants show they can pay rent without using the court's escrow account. In the situation, a bank statement could be enough to prove that they have the funds. This is a lot more accessible to pro se tenants who are mostly unaware of the escrow requirement, and in practice, this means that tenants with meritorious habitability claims are less likely to be evicted. The last issue is that current law doesn't actually require landlords to repair habitability issues. Instead, it requires landlord quote unquote best efforts. This is a mushy legal standard that's problematic for a few reasons. First, best efforts language means something different to each judge, and it leads to arbitrary and inconsistent decision-making in a courtroom. It creates inconsistency and unpredictability for both tenants and landlords. Next, it's a low standard that does not require proof of actual remediation and consequently allows conditions that have been deemed under Nevada law to be dangerous and unlawful to continue perpetually. Lastly, this language allows landlords to intentionally fail to comply with law and face no financial or legal consequences. AB 223 addresses these injustices in sections 10, 11, and 12. In sum, AB 223 closes long-standing gaps that make it almost impossible for tenants to assert habitability claims. It strengthens habitability law overall by promoting clearer legal standards and procedures that benefit both parties. All Nevadans deserve safe, healthy housing and the power to demand it without risking homelessness. That's what AB 223 will deliver. Thank you for your time, and I'll pass it back to Assemblymember Considine.
Thank you, Venetia Considine. For the record, we also have Jonathan Norman with the Legal Aid Center of Southern Nevada in Las Vegas, and we're happy to answer any questions.
Thank you so much for the presentation. Again, thank you so much. We always love seeing our Boyd Law students, and we know they're the future of our state. So thank you for being here as well. Do we have any questions from the committee? Senator Ellison.
Thank you, Madam. You know, I've seen tenants try to get out of paying rent, and they would say that the power is going on and off in the middle of the night and during the day and stuff. So we went out and checked, nothing wrong. So we put recorders on there to see if what was going on, where we could find it. Never went off. We had smoke detectors. People say they're not paying their rent because smoke detectors are going on and off. And they have a tendency to do that at different times. So we put recorders on them also. And the two that I'm talking about were strictly, they were behind on the rent, didn't want to pay the rent, and they looked for violations. So what would this bill do to stop, to make it a fair, I mean, mold is one thing, but.
Thank you for the question, Senator Ellison. If Venetia Considine, for the record, if I can have Mr. Norman answer that question, please.
Thank you for the question, Senator Ellison. So if it's a habitability issue under 0.355, this gives the tenant the ability to get into court. And as part of that, they can withhold their rent. That doesn't mean they don't pay it. They're just going to withhold it until a judge makes a decision. If they're unable to withhold that rent, then we go to section, or if they're unable to file a verified complaint, which there's a lot of reasons somebody might not be able to. There's a cost to any filing. So you would go to subsection 11, which is on page 11. And in that instance, the tenant would not have a defense to a summary eviction if they withheld rent without going through without escrowing their rent with the court, unless the judge decided that there was good cause to deviate from that. So in all instances, you're going to have a judicial officer making those determinations. It tries to strike a balance between a tenant having access to the courts, which currently, as was outlined, they do not for NRS 118A.355 habitability issue, and they are left to withhold rent under the current law through escrow and wait to be have an eviction notice put on their door for non-payment of rent.
With that, at that point in time, for the cost and the tie-up of the landlord, would that allow him the rights to evict at that point in time?
Jonathan Norman for the record. Oh, go ahead. Sorry, Assembly Member.
No, I didn't. Venetia Constein, for the record, I was waiting for you to answer, but I think that answer is yes. There still needs to be the rent escrowed, and if there is they go to the court and the court says there is no issue, then the court would, and Mr. Durbin can clarify any points that I'm missing, the court would give that escrowed money and anything that the court orders to the landlord.
Jonathan Norman for the record. Nothing to add. Thank you.
Tag team. All right. Do we have any more questions from the committee? Senator Scheibel.
Thank you so much. I'm curious if this is how other states handle these issues and if that's where some of the language came from, or if we invented the wheel in this case.
I think I can take that one, Jonathan Norman, for the record. Thank you for the question, Senator. A lot of this was applying the Uniform Landlord-Tenant Act to Nevada, not adopting it in whole because uniform laws have to interact with our laws and how things are working in Nevada. So we took pieces of the uniform law and wove them together with our law. So it's not an exact copy, but it takes in the context of Nevada law. So it is not reinventing the wheel, but it's also recognizing that uniform laws often don't fit the needs of jurisdictions completely. So it's a hybrid. Thank you.
Senator Daley.
Thank you, Madam Chair. Maybe just some comments on some of the stuff. I have some concerns over it. Hopefully we can get it all worked out. So who determines loss of value? The way I read it is the tenant is going to determine that, and there's no real framework guidelines towards that. A couple other definitions. I know you guys, and you spent some time taking out reasonable effort by the landlord to correct, saying that was an unfair reference because there was no timelines on that. However, in section 13, subsection 3, you guys used the word that the tenant has to be provided with a reasonable length of time to gather his belongings with no definition. Good for one's got to be good for the other. So anyway, just a couple of concerns over some of that language.
Thank you for the question, Senator Daley. I would like Venetia Constein, for the record, I would like to just talk about loss of value, and then Mr. Norman can answer the rest. The loss of value, when you file a verified complaint with the court, you have to put in what your damages are. So in that context, the tenant could make, my air conditioning is not working, that's got to be like, it's July, half of my rent, or whatever they come up with. But that is a determination for the court to make, but something does need to be listed in the complaint. And Mr. Norman, if you wanted to clarify that or answer the rest of the questions. Thank you.
Jonathan Norman for the record. Thank you, Senator Daley. So the court would ultimately make that determination. We had discussions in January and February about listing out, an AC in the summer is worth this percentage of rent, or a sink or a shower with sewage backing up in it is worth this amount. I think, we trust our judicial officers, and certainly in some instances, our clients are going to feel like the court made the wrong decisions. And I'm sure in other instances, the landlord is going to feel like the court made the wrong decisions. But at the end of the day, we have to trust the discretion of our judicial officers on this, because I think it would be overly prescriptive to try to list out every possible habitability issue and what the value of that is, both based on the number of people living in the unit and the ways units vary. On section, it's on page 15, the second part of your question. The reasonable in section 13 on page 15, 3A. I do think within a reasonable length of time to gather his or her belongings, I do think we would be open to putting a timeline on what that looks like. I think it's a good point that what's good for the goose is good for the gander. Thank you.
Understood. Thank you. And with this and a couple other bills that are coming up on landlord issues and various things in honor of Star Wars, we missed it. I think the landlord ward's just begun. They have.
I did have a quick question. I noticed the language was put in here that there should be clear and convincing evidence showing that a landlord is not liable for non-habitable conditions if it's the fault of the tenant or guest of a household. And I was just curious about the addition of clear and convincing, if that's something that had come up a good deal and that's why it was added, or just the history behind it.
Jonathan Norman, for the record. Thank you for the question. So I'm looking, I think the first instance of that, because it's repeated a couple of times, is section 11. And then it's in subsection 2A. So that was just trying to provide a standard in there for when that can be used. So for a condition, and it reads, the tenant may not proceed under this section for a condition caused by the tenant's own deliberate or negligent act or omission, or that of a member of his or her household or other person on the premises with his or her consent. So that's how the law read. And it's just putting in a standard there, so it's not just the landlord saying this was caused by the tenant, that there's actually something in there that needs to be shown by the landlord beyond just stating it in court, which is what we find happens. Thank you.
Thank you so much. And with that, I am going to have you take a step back from the table. I would remind everyone, Me Too, ditto works as we continue through this, just because we would like to get as many people as possible the opportunity to speak. And I think we're going to switch it up, and we're going to start in Las Vegas this time around, though everyone's welcome to fill in the table in Carson City as well. But we will get started in Las Vegas to hopefully get a few of you who didn't get a chance last time to testify in support of Assembly Bill 223. I would point out that we have our floor starting sooner than later, so I am going to have to ask you to keep it to 2 minutes and ask you to be as brief as possible, but we want to get as many people in as possible. So please begin in Las Vegas when you're ready.
Good morning, committee. My name is Rayanna Meadows, MEADOWS, pronoun she, her. I'm a housing justice organizer here with Make the Road, Nevada. And I'm here to speak strongly on support of Bill 223. I had a serious mold problem in my home. Even after I reported it, it took my landlord nearly 3 weeks to address it. During that time, I was living in those conditions with my 3 children who became sick from the mold exposure. No parent should have to watch their kids suffer in a place that's supposed to be safe. This bill is important because it ensures that landlords are held responsible for maintaining habitable living conditions. It protects families like mine and gives tenants the right to live in homes that are safe and healthy. So yeah, thank you. Thank you for your time, and I urge you to support Bill 223.
Thank you, committee. My name is Val Thomason, and I'm here as an organizer for Plan Nevada. I once rented an apartment years ago now with the notorious Gray Star Properties. The very first night that I moved into this apartment, I discovered that it was infested with roaches. It was more infested than I'd ever seen in my life. It was so bad, if I turned the lights on, the floor would move. I spent my nights in that apartment sleeping on a plastic chair in the living room because I was so afraid that they would be crawling into my bed at night. When I investigated the problem and I looked around the house for where they might be coming from, it was water and mold in all of the walls, under the sinks, inside the walls, everywhere. So I did move out of there. But when I first saw this bill, I thought of those apartments, and I went back there to ask the people living there if they were experiencing the same thing. And it was so horrendous that doors that I approached already had roaches seeping out from under the doors, crawling up the windows to where I could see them from where I was standing. And when I went to my own unit that I lived in 6 years ago, they told me that they still had the exact same water damage and the exact same pest infestation. So what she said earlier about them not actually fixing the problem through these eviction proceedings is true. 6 years went by and nobody had ever held them accountable and asked them to actually get rid of the roaches and the water problems. Instead, they were just moving people out and moving new people in to keep dealing with the same problem. So also here in support, and thank you for your time.
Good morning, Chair, members of the committee. My name is Tamara Favors. I'm an organizer with Plan as well. I'm also going to read remarks from a community member. Good morning, members of the committee. My name is Noah Cicinero. I'm a paralegal and a poet in Las Vegas community. I am here with the group Progressive Leadership Alliance of Nevada. In Las Vegas, 45% or approximately 108,000 households are renters. This bill would possibly affect half of the city. As Eric Postel repeatedly pointed out in his book Politics, friendship is essential to having a great city. At the moment, the relationship between landlord is one-sided. The landlord controls conditions and destinies of the renter. What the landlord wants, the landlord gets, while the renter is left in dismal conditions and feeling powerless. The rents have risen to $1,400. The renters are contributing heavily to this apartment, to the apartment community's mortgage, but instead of being treated as co-owners, renters are treated like their lives mean nothing. AB 223 will create friendship between the landlord and renter. It will create incentives for the landlord to make better living conditions for their renters, and the renters will feel more empowered to create better conditions for their households. AB 223 will generate over time a cleaner and more beautiful, more healthy, and more livable and more friendly Nevada.
Hi, my name is Jaira Mendez. I'm a proud YAJAIRA-RIMENDES, and I am a proud member of Make the Road Nevada, and I urge you to fully support AB 223. I strongly support the revised provision relating to the habitability issue. As well, I am a 32-year-old with cancer. This former landlord I wrote a verbal and as well written letter to fix the gas leak valve in my RV. And due to the gas leak, it caused me to get sick. I had dizziness. I had resulting in going to the hospital for carbon monoxide poisoning. As well, the AC I had issues with, and it broke and it lasted 2 months. As well, the floors. He didn't fix anything. He didn't do anything within 2 months of finally getting everything. He told me that I had to pay out of pocket another $1,500 out of pocket. So I bought everything and he installed everything. And after that, it was a risk to my life, because it took me almost 2 months to finally get it fixed. As well, the lawmakers, please support AB 223. Thank you.
Thank you. We're going to take 2 more in Las Vegas, then we're going to come to Carson City and then to the phones.
Good morning, Chair, members of the committee. Ariana McConnell, ARIANA-MCCONNELL, third-year student at William S. Boyd School of Law and student attorney with the Tenants' Rights Clinic. I'd just like to ditto all the presentation and testimony in support of this bill. AB 223 would benefit thousands of Nevadans who deserve the dignity of having clean, functional, dependable housing. So I ask for your support. Thank you.
Good morning, Madam Chair and members of the committee. For the record, Constantine Arhantis, CONSTANTINE-ARHONTAS. Sorry for the long name. As another third-year law student at Boyd, I am glad to support my peers. In support of AB 223, I'd like to recall a personal experience. I was a law clerk at the Legal Aid Civil Law Self-Help Center in 2023. That summer, Vegas saw record high temperatures and record high eviction numbers. Each month, hundreds of tenants came in for help after receiving eviction notices, with many just figuring out that they had valid habitability issues. They were each on a 7-day clock to understand the eviction and habitability processes, file a complaint, put rent into escrow, arrange for substitute housing, and for many, to arrange for days off of work without losing their jobs. If they could not accomplish all this within a week, they faced the prospect of moving out on short notice in the face of triple-digit temperatures and hot asphalt. Many did not have the time to gather personal belongings. It is easy to take for granted the creature comforts of a safe, clean, and air-conditioned home, but for many, it is currently a struggle to obtain these basic necessities of modern life in the desert. I urge the committee to pass AB 223 and make it easier. Thank you.
Thank you. We're now going to move to Carson City and then to the phones.
Thank you, Chair Pazina, members of the committee. Ben Innes of the Nevada Housing Justice Alliance. On behalf of our coalition, we urge your full support. Thank you so much.
Good morning, Chair and members of the committee. For the record, my name is Tara Webster. I'm here on behalf of the Progressive Leadership Alliance of Nevada in support of AB 223. From 2017 to 2019, my husband and I moved into our first rental together, a charming duplex in the heart of Midtown Reno. It wasn't long after we moved the charm wore off, because during our first winter, the single-pane windows started to leak and the frames were covered in mold. After each snowstorm, water seeped into the basement through cracks in the foundation walls. And then when the 40-year-old in-unit washer broke, a 2-month delay in a home insurance-approved repair meant hauling our laundry to the laundromat, even though a replacement would have been very inexpensive. Our landlord neglected necessary repairs and proper remediation after the sewer line backed up and flooded our basement, instead opting for superficial cleanup using a shop vac and a box fan. There was no disinfection. Despite refusing to replace the windows without imposing a rent increase on us, the landlord could very much afford personal luxuries like attending regular vacations and taking his art card to Burning Man. He didn't have a backup to do any type of fixes on his own property. Providing a habitable home is a minimum standard of human decency, and landlords and property owners have a fundamental obligation to ensure that their housing does not jeopardize tenants' health, safety, or quality of life. We urge you to support AB 223. Thank you.
Hi, my name is Emmy Miranda, EMYMIRNDA. I'm the Housing Justice Organizer with Make the Road Nevada, here to support AB 223. This bill is crucial for protecting tenants and holding landlords accountable for maintaining a habitable living condition. I've personally experienced the impact of landlords neglecting living conditions. I lived in an apartment for 3 years with my family that had severe mold issues that affected my respiratory health. Despite repeatedly raising concerns, our landlord ignored them. I struggled with breathing issues from ages 12 to 15, and eventually, after rent increases, we were forced to move. AB 223 addresses these issues by requiring landlords to maintain safe, habitable living conditions and allowing tenants to file complaints for quicker relief. This bill would have been invaluable to me and my family at that time, which is why I ask you today to please support Bill AB 223. Thank you for your time.
Thank you. We're going to take one more in Carson City, and I believe there was a gentleman in a Dodgers cap who's tried twice to speak now in Las Vegas, and he was at the table. If he'd like to return to the table, we will get to him before we go to the phones, and we can proceed in Carson City.
Thank you, Chair. Good morning, everyone. My name is Serena Evans. I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. Housing, accessibility, and stability are intricately connected with violence prevention and intervention, and there have been numerous studies on habitability and increased risk of violence, so we are in strong support of this bill. Thank you.
Thank you so much. I don't know if that gentleman's coming back again in Las Vegas, but we'll go to the phones and then I see him coming. So we're going to get to him, and then right after that, we're going to go to the phones. I don't want to shut him out twice, although he did shut my Braves out twice. You may proceed when you're ready.
Hi, good morning. My name is Alejandro Ramos. I am a member to Make the Road Nevada. I am here in support for the Bill 223. Thank you.
Thank you so much for being here, and we're so happy we got a chance to hear from you. And with that, we are going to move to the phone lines. So if there's anyone on the phone lines broadcast who'd like to testify in support of Assembly Bill 223, we would love to hear from them.
If you would like to testify in support of AB 223, please press star 9 now to take your place in the queue.
Good morning, Chair, Vice Chair, members of the committee. This is Dora Martinez with the Nevada Disability Action Coalition. I want to thank your Zoom lady who's very on top of things. Thank you, ma'am. We wholeheartedly support this bill. As a blind person, I'm very grateful that my kids are sighted, because when I lived in my old apartment, they came and they saw my wall had mold. So we reported to the person, to the office, but then they didn't do anything. So we moved out. So this will make our, we pay rent on time, and this would help us make sure that the landlord are held accountable. Thank you. Have a good day. Come on.
Hi, good morning, Chair Fazina and committee members. My name is Brian Harris. That is BrianHarris, and I'm calling in support of AB 223. This is a really good bill, and I would urge you all to support it and pass it. Thank you.
Cyrus, Hojjaty. We support this bill. Good morning, members of the committee. Thank you so much to all the sponsors that brought this bill. Very helpful and very interesting stories. Learned a lot. Thank you so much.
Katrina Grigsby, CatrinaGrigsby, for Nevada Homeless Alliance. I'm in full support of this bill.
Thank you so much. Do we have any more callers on the line broadcast?
We have 2 more callers, Chair. 1 second. Caller with the last 3 digits of 495, please press *6 to unmute. Again, caller with the last 3 digits of 495, please press *6 to unmute. Thank you. Please continue.
Yes, hi. Yes, hi. My name is Glenda Hairston, Glenda. Last name Hairston, Hairston. I'm a proud member of Make the Road Nevada, and I am in support of Bill AB 223. Thank you. Good morning. My name is Rochelle Clark, Clark. I'm a proud member of Make the Road Nevada. I am in support of AB 223.
Chair, you have no more callers in support at this time.
Thank you so much, and thank you to everyone so much for being here to testify on all of our bills so far today. And with that, we are going to move out of support and into opposition on Assembly Bill 223. We will start at the tables in our physical locations, and then we will move to the phone lines.
Madam Chair, members of the committee, happy belated May the 4th and happy Cinco de Mayo. For the record, my name is John Sandy, Sande, here today on behalf of the Nevada State Apartment Association. I want to begin by acknowledging that housing policies in Nevada are real, and that both tenants and landlords deserve a system that's fair, predictable, and functional. But I respectfully submit that AB 223 does not improve that system. It just disrupts it. Our concern is not just that the bill is unnecessary in many places, but that it risks creating ambiguity, unintended consequences, and unfair burdens that will ultimately hurt housing access in our state. Nevada's landlord-tenant laws, particularly under Chapter 118A, could be improved, but they are largely balanced. Our state already requires landlords to maintain habitable properties. Tenants have the right to withhold rent when landlords fail to meet these obligations. And there are existing remedies for poor conditions, including rent offsets, lease terminations, and legal recourse. Now, it's been, at least the way I understood it, it's been represented that tenants, unless they are taken into an eviction proceeding by a landlord, do not have access to courts. I just want to make sure the record's correct. They absolutely do. 118A 355, and I pulled it up so that I could read the different recourses that tenants have. If a landlord fails to maintain habitable premises. They have the ability to terminate the rental agreement immediately, recover actual damages, and sub C, apply to the court for such relief as the court deems proper under the circumstances. So they absolutely have the ability to preemptively challenge a landlord's maintenance of his or her habitability issues under the law. In fact, the current system was primarily developed through collaboration with John Sasser, representing Washoe Legal Services, and Housing Advocates in 2007. It was designed to prevent abuses by either parties. As it recognized, if you go through the history of that, there was a lot of the landlords associations were bringing up a lot of the same issues that we're bringing to the table today, especially regarding withholding rent and some of the other ways that will make the process cumbersome. But I think that it has played out pretty well in the way that the system has been working. We believe that AB 223 would undermine the existing balance by imposing strict timelines that may be impossible to meet, especially for small landlords. So, for example, in Section 12 requires certain repairs to be made within 48 hours, and the court is not allowed to look at the good faith and reasonableness of the landlord's actions. It removes the court's discretion to consider whether the landlord acted reasonably or in good faith, and instead imposes triple rent penalties even in situations where actual harm may be minimal. And perhaps most troubling, it requires landlords to prove that tenant caused the damage by clear and convincing evidence, a legal standard typically reserved for fraud or constitutional claims. That's almost impossible to bar for a landlord to meet, especially when the landlord does not have access to the unit. I know I'm beyond my 2 minutes. I will submit the remainder of my testimony, but thank you for hearing me out.
Thank you. Yeah, we went closer to 3. I wanted to give you a little bit of latitude. And yes, do submit those comments, and thank you for being here. And I know that you'll continue working with the Assembly member.
Madam Chair, can I ask him a question?
I think, actually, before you go too far, sorry about that, we do have a question for you from Senator Steinbeck.
Yes, thank you. You mentioned that the tenant has access to the courts, but does that require an eviction notice?
It does not. The way I read the law, under 118A.355 and 118A.390, there's 2 statutes that allow a tenant to file a verified complaint to seek redress from the court.
Okay, thank you.
Okay, thank you so much.
Good morning, Chairperson and members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber. For the sake of brevity, I'll go ahead and echo the comments made by my colleague and just add we do share the concerns that Senator Daley mentioned regarding the reasonable effort language that was stricken, especially just given recent federal actions and the reciprocal global response. This could drastically increase wait times, and trying to meet that shortened window for compliance could also drastically increase costs that would end up being passed on to the renter down the line. Thank you so much.
Good morning, Chair Pazina and members of the committee. My name is Azim Jessa, Azimjessa, and I serve as the Legislative Chair for the Nevada Realtors. I appreciate the opportunity to testify today in opposition to AB 223. We recognize and appreciate the amendment made in the Assembly, which addressed several of our initial concerns. However, we remain opposed to this bill in its current form. Our opposition centers on a few key provisions. John addressed the first one regarding clear and convincing evidence, so we'll skip over that one. Section 2 here, in our next point, the bill removes consideration of good faith efforts. So again, that was addressed, so I'll skip over that one to save us some more time. I'm missing my coffee and pastries in room 2200 right now. Third, we strongly oppose allowing the filing of the verified complaint regarding habitability to serve as a defense against all types of summary evictions. While this may be appropriate for cases of non-payment or rent, it is not appropriate for other types of violations such as holdover tenancies, material breaches of lease considerations, unlawful business activities, or subletting without consent. Other examples would be waste of premises, nuisance, or violations of the Uniform Controlled Substances Act. These situations are all unrelated to habitability and should be addressed separately. Fourth, the proposed requirement for landlords to provide a signed rent receipt presents a logistical and operational challenge. Many tenants today pay electronically or deposit directly into a landlord's account using pre-provided slips. Both of these already produce a time-stamped receipt. Requiring the landlord to provide a separate signed receipt for every transaction could force it return to in-person rent collection, which would inconvenience all parties. Tenants would have to take time off work, and landlords may need to restrict rent collection to specific hours, eliminating the flexible and modern payment methods. Finally, we do agree bad acting or non-responsive landlords should be held accountable accountable. Existing law already provides tenants with remedies in such cases, but AB 223, as currently written, risks penalizing landlords who are actively working to address habitability concerns. The bill overreaches in ways that may discourage property owners from staying in the rental housing market, and this is at a time where Nevada needs more housing providers, not fewer. We urge you to oppose AB 223. Thank you for your time this morning.
Thank you so much.
Good morning, Chair Pazita and Vice Chair Daly and members of the Senate Commerce and Labor Committee. For the record, I'm Mindy Elliott, representing both the Nevada Rural Housing Authority and the Southern Nevada Regional Housing Authority. We acknowledge the intent of AB 223 to enhance tenant protections. However, we must express our opposition to the bill in its current form. The expanded definitions of habitability and the expedited complaint procedures, while well-intentioned, may inadvertently impose significant challenges for housing authorities, particularly in the rural areas, where access to maintenance services and resources can certainly be limited. We are concerned that these provisions could strain our resources and potentially impact our ability to provide affordable housing options to low-income residents in our communities. We urge the committee to consider amendments that address these concerns, ensuring that the bill's objectives are met without compromising the viability of housing programs serving Nevada's most vulnerable populations. We'll continue to work with Assemblymember Considine on further amendments. We thank you for the opportunity to provide our perspective, and we hope you have a great day.
Thank you so much. We are 17 minutes past when we were due on the floor, so we are going to try to keep this very brief. Do we have any callers on the line broadcast who would like to testify in opposition of Assembly Bill 223?
If you would like to testify in opposition of AB 223, please press star 9 now. Chair, you have no callers in opposition at this time.
Thank you so much. Broadcast, we don't want to leave you, so we're going to stick with you and see if there's anyone who'd like to testify in neutral, and thank you.
If you would like to testify neutral on AB 223, please press star 9 now. Chair, you have no callers neutral at this time.
All right. Is there anyone in the room who'd like to testify in neutral? Not seeing anyone neutral on AB 223. Do we have any closing statements? Thank you so much.
Thank you, Madam Chair. I would like to have our final remarks done by Mr. Norman in Las Vegas, if that's okay with you.
Absolutely.
Venetia Considine for the record.
Thank you, Chair, and I'll just be a moment. So in point 355, there's currently not a verified complaint. There is the ability to file an action in small claims court that's disconnected from the landlord-tenant context and is not a reasonable access to the courts. Reasonable access to the courts means, for us, means getting into the court that deals with landlord-tenant issues. And also, I wanted to point out that in Section 13, it's subsection 2C. The last bit of that is, if the landlord can show by clear and convincing evidence that the restoration could not be accomplished within the notice period. So when people talk about supply chain issues for essential services, there is the caveat that the landlord could come to court and show that they were not able to make that repair because of an issue outside of their control. And I think that concludes the closing remarks. Thank you so much.
Thank you. And just for Venetia Considine for the record, just for clarification, small claims court is only for money. You can't have behavior changed or something fixed. Thank you.
Thank you so much. And let us know if there's any further discussions with stakeholders. And we really appreciate your time today. And with that, we will close the hearing on Assembly Bill 223. And we will go to our last order of business, which is public comment. We would welcome anyone to come to the tables in our physical locations or join us on the phone. Not relating to any of the bills that were discussed today, but if you'd like to speak to us about an issue relating to commerce and labor, we'd love to have you come up. Just a reminder to state and spell your name for the record, and you will have 2 minutes to speak. And not seeing anyone, everyone's heading for the doors and not the table. So we also would like to thank everyone who came out in Las Vegas as well as Carson City today. We really appreciate your engagement in the legislative process. And we will move to the phones broadcast, who got a shout out earlier, and we thank you for the job you do. Is there anyone waiting on the line to share public comment?
Thank you, Chair. If you would like to participate in public comment, please press star 9 now. You have no callers wishing to participate in public comment at this time.
Thank you so much. And with that, we will be back here at 8 a.m. on Wednesday morning. And we wish everyone a happy Cinco de Mayo and hope everyone had a wonderful May the 4th be with you. And I believe we have one comment from Senator Flores before we adjourn.
Thank you, Madam Chair. Just wanted to make sure, in the spirit of Cinco de Mayo today at 5:30 p.m., we want to invite everybody joining us today for our annual Cinco de Mayo celebration right across the street at the Piazza. Hopefully you can all join us for food, drinks, and just have a good time.
And with that wonderful announcement, we are adjourned.